there is an urgent motion which is being filed, my lord. What has happened is Calcutta police was recruiting for lady constables and constables. Now, they have done away with the 5 years relaxation of age, upper age limit to home guards recently. We had challenged it before the tribunal. The matter was being heard, but because there is no bench, in the meantime, they have fixed the date 21st December for the preliminary examination. Unless we are allowed to appear or whatever your lordship feels, we'll be out of the way for the total period, my lord, because we don't have any more years. So, my lord, I'm filing it, my lord, affirming it just now. And I'm giving this slip. The number we'll give, if your lordship can take up on Wednesday, subject to your lordship's pleasure.
Come with the number.
I'll
It's
give
on
the number,
21st. You come with the number.
lordship. Or I give the slip, my lord, and I'll give the number. It will
Yes,
come.
you give the number. Then let it.
Okay, I'll give it.
You give the number.
Lordship. I'm great.
If I may have your lordship's kindly mention a matter, your lordship. It's matter that was supposed to be taken up tomorrow. Your lordship, I'm appearing on behalf of the appellants.
Fixed matter.
Fixed matter, your lordship.
2 p.m. Lord, specially fixed by your lordship.
Tomorrow.
Yes.
Objection of the Honorable Supreme Court, my lord.
Yes.
Yes, your lordship. But I'm appearing on behalf of the appellant, your lordship. The advocate on record was supposed to appear, but due to the ongoing flight cancellations, your lordship, he's unable to come tomorrow. There are
Let us see. It will be on the list. You be here. Don't worry. We'll see.
Mention one application on the matter was heard by the previous honorable bench. Therefore, the matter is not solved. This application have been on any day
It
subject
was heard by the previous bench.
submit
So what do you want?
for inclusion.
For inclusion, you give next monthly list. What is it for?
Order not forward the pencil long after 18 years that has been cited. They are 5 minutes I have. Already filed the application, but not that person we are suffering from. Let me start the
It is arising out of the writ court's order. We list the can next week on the day fixed for interest.
I permit to mention hearing 24, madam.
Please inform the other side.
Madam, inclusion in the list, madam. Hearing matter, madam. WPST.
Inclusion monthly list.
No one.
place the facts.
You are for the state
Yes, this is state is a
writ petitioner.
and the FIR was lost under second C-76 before the London court. Then when the trial was going on before the London session judge in Nodia. But the London session judge directed the SP to take steps against the IO. Because instead of basically arresting the X, arrested the Y. Then Malad, we have initiated a disciplinary proceedings against the respondent. But after charge sheet was issued, disciplinary proceeding was concluded. But he was punished with taking up 2 incremental benefits. And against which paper, appeal dismissed, then filed a revision was dismissed. He challenged the order before the tribunal. Tribunal, without going into the merits of the original application, set aside that entire order on the ground that since no presenting officer was appointed, entire proceeding is vitiated because there is a provision for appointment of presenting officer under the Westmoreland Transmission Control Act rules 1971. That should have been followed. Under that, and he has filed an application before the December court that since the tribunal has not considered the merits, entire matter may be remanded back to the
Tribunal.
no bilateral court of trials. That since no merit has been discussed by the lower tribunal, and on same issue, it's two division bench of December court considered the issue.
No, the tribunal that remanded it to the disciplinary authority.
Setting aside the entire tribunal.
Obviously, unless it is set aside, what they will remand.
Kindly see the first division bench judgment of our High Court. That is
Let us see first the tribunal's order.
Yes.
Just allow us to go.
Yes. at page on an impugn order.
What is the date of the order?
24th of August 2020.
That is not the issue here. Four 24 order. OA 375.
Yes. OA number 216 of 2020. 24th August. 24th August.
The OA is 375 of 2017. Three 75 of 2000. Well, they have given 173 of 24. Oh. What is the respondent's name?
Abhijit Bhatt.
The wrong file.
116 of 2020.
The wrong file.
Please.
But that's not on list today.
That WPST number 173 of 2023.
Wrong file. Wrong file. Yes.
But there is not a single sentence uttered before the Donnet Tribunal that non-appointment of the inquiry officer he has suffered in natural justice. Rather, he has filed an application before the Supreme Court, this scan number 1 of 2023, that entire order may be set aside, matter may be remanded back to the tribunal for hearing of the on merits. On the same point, kindly see, the learned tribunal relied upon notification dated 19 September 2014, that is at page 169. Kindly see page 169. This is applicable to whom? In the police force in West Bengal, police personnel are guided under the Police Regulation Bengal 1943 up to the post of inspector. The incident took place when he was a sub-inspector. 19 September 2014, in exercise conferred by proviso of Article 309 of the Constitution of India, the governor is pleased to take the immediate effect following amendment to the West Bengal Classification Control Appeal Rules 1971 as amended subsequently list below. Then, Rule 4 capital A has been amended,
It has been inserted.
extracted. And how this rule could be made applicable to the police personnel, whether the tribunal has got jurisdiction to make the law under Article 309. But that has been discussed by a division bench or High Court. The 309 rules made applicable to the non-police personnel.
And where is the regulation that you are relying upon?
Yeah.
Police regulation. They have given copy of police regulation.
Well, okay. Police Regulation Bengal 1940.
Yes.
661. I've read at least 2 of the case. I don't find any provision for appointment of the presiding officer. And not a single question I've been asked by the presenting officer, inquiry officer.
Which provisions deal with, which are the provisions dealing with the proceeding against the members of the force?
But this section, 1943, applicable to the police force.
No, where are the provisions relating to conduct of proceedings?
861 Mara Kalki. Or 856 punishment. But there are two kinds of punishment, major punishment, minor punishment.
8,
Chapter 17, 856, 857 and 850. Major punishment, minor punishment. Then how procedure, 861. Got it. May I hand over by?
This is volume 2 of. Come on. Volume 2 is required. Oh, volume 2 is required. একটাই আছে নাকি? Ask for volume 2.
Pilot character.
Hmm. This regulation.
Okay, got it. But Kanishi, that circular of 2014, how could be applicable to the police force? Police force guided on the police regulation of 1943. A detailed procedure has been provided. There is no such provisions for appointment of presiding officer.
So who will examine the witnesses?
But, in the present case, the delinquent is cross-examining the witnesses.
Who?
The delinquent officer concerned, cross-examine the witnesses.
No, who examined the witness on behalf of the department?
Department. Questions are put by the department authorities.
So what is the meaning of 861D? D, C, D?
Yes.
You don't have just one book. Very difficult. Please see what D says.
Oral inquiry shall be held. Person charged so regard it offered to put drawn of the proceedings so that and the inquiry or oral evidence shall be heard as to the allegations are not admitted. The person charged shall be entered to cross-examine the witness. And
So oral evidence shall be heard. Who will hear the oral evidence?
oral evidence by the inquiry, sir.
He will hear it. Who will present it?
Oral-
He will present it and he will hear it.
No, the provision. But pre-provision is there.
Huh?
There is no provision for presenting of charge.
No, but then he will hear. It says the inquiry officer will hear the evidence. You have just read.
And oral inquiry shall be held if the person charged so declared or if the authority who has drawn up the proceeding so direct. At that inquiry, oral evidence shall be
Heard. So the evidence, oral evidence will be heard.
heard by the inquiry.
Inquiry officer, who will present it?
But there is no question of presenting of charge.
Then how he will hear it? Unless the evidence is presented, how can he hear the evidence?
At the inquiry, oral evidence shall be heard to such allegations as are not admitted.
Correct. So the moment, if he admits, nothing is required to be done. If he doesn't admit, then evidence is to be heard by the inquiry officer. He will hear the evidence, so somebody has to present it. That is a natural corollary. Otherwise, how it can be heard? And if it has to be presented, who will present it? Where is the provision? If there is no provision, what is the only logical way of examining it? You tell us. Or the legal way. He will not ask if he is to hear the evidence, then he is to hear it in a quasi-judicial capacity with a view to asserting its veracity, reliability, admissibility. So who will present?
Now, I find from the inquiry proceedings, all the witnesses produced by the defense witness, prosecution witness, cross-examined by the
That's not the point. Point is he has to hear the evidence. It does not say that he will record the evidence. It says he will hear the evidence. Under certain paramilitary rules, force rules, you will find that there is a recording officer. He records and he sends it. This is not the thing. Here he has to hear it. He has to record a conclusion. Then he will send it.
that this for same person, Calcutta police and Bengal police and all over, and this has been upheld by our High Court.
Maybe, we don't know. We will see that. But we are asking you right now from bare perusal of the rule. It does not say that he is a recording officer. He is an inquiry officer. So the moment he is an inquiry officer, he becomes a quasi-judicial person. Then how he can be a judge and prosecutor both at the same time?
That charge was not before the Ghana trial.
No, but that if there is such a glaring irregularity in the proceeding, illegality in the proceeding, then can we shut our eyes to it?
No, but in that, I mean, whether this memo of 2014.
Forget about the memo. We are not on the memo. We are asking you, memo apart. Just leave the memo apart for a minute. It is, you must have seen in some CRPF and these BSF, there is a provision for recording officer. He is a recording officer. He will record and send it. Those are summary force, something it is called. Summary proceedings. This is not, this is a regular inquiry where there is an inquiry officer. He has been termed as an inquiry officer.
No doubt about
So once he is an inquiry officer and he is not a recording officer, can he question the witnesses like this and present the case?
proceeding. Not a single question has been asked to the delinquent.
Then all the more, then there is more infirmity.
No, but this one has to be taken before the London tribunal.
If there is such an illegality apparent from the record striking at the root of fairness, can you raise this plea that it was not raised there, therefore we should not look into it?
This question has been decided by our division bench or high court. So we do it.
That no inquiry officer is required.
There is no such person.
We are not on that. The coordinate bench has held that in absence of inquiry officer, the proceeding will be valid. Where is that, judge?
On the time, WPSC number, petition number 16, I am of the state of West Bengal. I got got it. Paragraph 3, thank you. Government approval appearing for the execution of substitute proceeding. As against the execution of presenting officer for the content, anchor officer acted as a presenting officer as to the anchor officer, he draws attention to the court to the case for determining the records of the proceedings of the proceeding. The anchor officer recorded that the examining the prosecution witness being started. The anchor officer, however, did not tabulate the question put forward by the anchor officer to the prosecution. Witnesses, according to the anchor officer, cannot put the question to the prosecution witness. If the anchor officer does so, the presenting officer describes the entire proceedings in the element of aspects to features the different proceedings. In support of his contention, he relied upon 2010 to association state of the also Saurabh Kumar China. London senior government non-appointment of the he submitted the reliance that appointment of a presenting officer is not a must unless specifically provided that the the facts of the presentation, the prosecution which was recorded by the interpreter. Some prosecution witness presented by the delinquent officer observation as to the quality of the exemption chief. She submits that the contention of vastness of the officer is unfounded. The restriction of supported refill proceeding. In the refill proceedings, no presenting officer was appointed. The issue is whether non-appointment of the presenting officer reaches the different proceedings or not. So such it is. Within the content of one, and Roman 2. Not specifically for the disability to appoint a presenting officer, you can end the employee. Non-appointment of the presenting officer itself not be said for a country. Common 2. Then the interest of leaving the position of the judge does not act as a presenting officer the position of the prosecutor. The interest of the view to arrive at the truth or obtain the clarification can put question to the prosecution witness and also the defense witness. In the absence of the presenting officer, if the interest of puts any question If as absence of presenting of server itself would not appreciate the inquiry and recognize that inquiry officer can put question to the AV or witnesses getting the truth. The question whether the inquiry officer acted in the presenting officer have to be decided in response to the manner. Then, madam. The principle as recommended above. However, the principle have to be applied in the fact situation or particular case. There is no requirement of appointment of presiding officer in case whether scheduled an appointment are silent. When the scheduled rules are silent, they began with the applicability of the fact of consent of the principle of nature in the activity with the principle of nature which are not physically excluded if scheduled rules are. But there is no exclusion of there is regulation against voltage. Page 8. That's the question whether the interpreter is supposed to act as the independent or interpreter has acted as a prosecutor or as a question of fact which has to determine the action of the prosecutor. The High Court has summoned the entire High Court gave to the conclusion that the interpreter it takes High Court found that the interpreter acted the High Court has already the person from the present case, the record of the proceedings should drawn to the court at the instance of the petitioner as also by the state. Demonstrate that the interruption recorded the evidence of the prosecution movement. Recording of evidence the chief was done. The interruption was allowed to process in the prosecution movement. There is nothing on record. Other than the interruption, leading questions from the prosecution sanction to the record to start the president. Before the Superintendent of Police with the disposal that he will give all opportunities to different areas that it did not carry the process of the inquiry proceedings conducted by the investor. This satisfaction is recorded in the order dated 19 March 2012, passed by the Superintendent of Police. Nothing is based on record. We have the recognition that the recording satisfaction to the case of the conduct by the investor was considered. However, too much now there to say something when a different proceeding conducted cannot be treated as a casual exam. The inquiry proceedings also cannot be conducted with such close mind. The inquiries are required to be under most of the does not accommodate a charge of bias in the control by to make then another of our children.
This has not dealt with the police regulation.
What?
This is not dealing with the police regulation. Where it says dealing with the police regulation?
Ratio.
Where does it say that it is dealing with the police regulation? You said this regulation has been upheld by the division bench.
Yes, that is another judgment.
In this case, the coordinate bench has taken into view the decision of the apex court, which says that whether it can be excluded or not will depend on the facts of that case. It does not say that by a rule it can be excluded. Secondly, the division bench found that before the superintendent, he did not say anything. He says, yes, I have been heard, I have been allowed all opportunity. So taking note of that, the division bench has this, paragraph 7 at page 10 of the judgment. Before the superintendent of police, the delinquent stated that he was given all opportunity to defend himself. In view of his admission, the division bench has.
But I consider who is the district attorney? Superintendent of Police.
Yes.
Superintendent of Police, was guided by order of which law?
But the rule has not been considered. The court has gone on the fact that there is no allegation of any kind of prejudice being caused. We don't.
That has been.
Yes. Whether in this case also he has admitted. There the division bench has taken note of an admission, not that he has not said.
Yeah.
He has specifically admitted.
Kindly see that.
Any plus which is the judgment of the apex court which the division bench has considered. Ram Lakhan Sharma case. 18-7.
670.
We have that, judge. You have given us. You have given us. You have. Two copies.
But division bench has considered paragraph 36 and 32.
Which judgment?
That's it, boss of judgment quoted this judgment. Paragraph 34. When the statutory rules are added with regard to the applicability of the process of the method, the applicability of the principle justice which are not specifically excluded because there is no express purpose of the particular body. It is the same that the applicable. That one noted.
T paragraph 36 and 37. That is the law. 37 is the law.
That's the question of also independent or income. The prosecutor not a question of fact which has to be decided the facts of the particular case.
37, sir, please.
Then I could having come to the conclusion that the officer acted as the prosecutor or
That is all. He has acted as prosecutor also. Now see what it says. The capacity of independent adjudicator was lost. The moment he has acted as prosecutor, the capacity of independent adjudicator was lost. That is the judgment.
that last sentence.
Yes.
We make it clear that all above observations are made about the facts of the
Correct.
present.
Yes.
Now what another judgment of our division bench. WPSC number 1 dated 16th August 22.
Yes, we have that. We have that.
Kindly see. Paragraph 3. Under senior advocate appealing for the report submitted to the private respondent, submitted to the Hospital Police, different proceeding was different proceeding governed by the provisions of Procedure 1943. In particular, draws the attention of the court to the resolution 861, just I placed people on it. It submits that the deputation does not enjoy a duty upon the authorities to appoint the presiding officer. The disciplinary proceedings, it points out that the facts of the present case, the inquiry report was accepted by the disciplinary authority. Disciplinary authority imposed punishments and statutory appeal to the college. Revision was also prepared by the private respondent. Therefore, the private respondent adopted approach to the tribunal. College senior advocate appealing said that the tribunal
We already have this.
notification dated 19th September
This is
2014.
Calcutta police regulation. They are referring to West Bengal police regulation. Yes, we already have. Volume 2, we already have.
Neighbor. Neighbor. Learned Indian Advocate appearing for the state points out that the tribunal relied upon the notification dated 19 September 2014. Submit such notification was issued to the West Bengal Services Prosecution Control Application Certification. The rules of 19 September do not apply to the sub-inspector of police and member of the subordinate police board in terms of the rule 4145 of 1971 rules. Senior advocate appearing for the submission that the tribunal is not through the issue of 2018 Supreme Court cases 617 India versus Ram Blocks of
Case of here also paragraph 20. Para 21, sir. Both these cases, the division bench has not said that there is no requirement. The division bench has said that in the case, no prejudice has been caused. It is not affirming the regulation that in the police service, the proceeding is to be conducted without a presenting officer. You see para 21. Same consideration. So the entire records of the inquiry were examined. The Honorable Division Bench came to a conclusion that no prejudice has been caused. Not that there is no requirement. If there is no prejudice, then natural justice, that is the law, cannot be insisted upon as a straitjacket formula. No, see, in both these cases, the inquiry record has been examined. In the present case also, we want to examine the inquiry. You have the records?
No.
Come with the records. Let us see the records. The judgment you are relying upon, in both the cases, the Honorable Division Bench has gone through the records of the inquiry and then made up a mind. Let us see the records. If the situation is same, we don't know. If situation is same, still there is some issue raised by him. What will be the consequence? If situation is not same, then totally different consequence.
Yes, find one application. Certification order demanding better treatment of part. Because this point was not part. Can number 1 of 2020. Can 1 of 2020. And application for any point demanding applies or any other.
ঘটনাটা ঘটেছে না এবং আমি অ্যাক্টিভ তার জন্য বলে তাহলে হাউ ক্যান বি এই যে গ্রাউন্ড অফ পেজ 51 স্টার্টস
And grounds of appeal at page 51 before the appellate authority. Not a single ground has been taken before the appellate authority. That I've been not been allowed to cross-examine, or there's a bias, and about the officer of the presiding officer.
No, that we will have to see whether he has raised that issue before the disciplinary authority or not.
He has not pleaded before the disciplinary authority also.
His reply to the inquiry report is on record.
Yes. The findings of the inquiry are at page 34. What between this? Statement of allegation. জি জি কোথায় কত নম্বর পেজ? চল্লিশ থেকে তেতাল্লিশ, চল্লিশ থেকে তেতাল্লিশ। And reply to the charge is page 41. So called. No. The charge sheet. Charge sheet reply. অ্যানেক্স করে বইয়েতে থাকবে তো বইটাই তো পুরো অ্যানেক্স করে স্টেটমেন্ট বইটা দেখছি রেটিংসটা খারাপ দিয়েছে রিডিং মানে এটা তো আছে বইটা দেখেন লাস্ট দিক যে বইয়েতে কোনো গ্রাউন্ডস নাই
Where is his statement of defense?
সাবমিশন হবে ওকে দুটো হয় না এই যে page 88 of the 8 of the repression page 88 of the repression হয় না হয় না 40 feet, huh? 80. Theater 9 into the theater.
Yes.
Your Lordship, seen not a single sentence uttered either in the written statement of defense or in the inquiry proceedings or before the appellate authority that he has been prejudiced for non-appointment of the presiding officer, or he has been prejudiced by any action of the national justice has been violated. I could have understood that in the grounds of appeal he has taken before the appellate authority. I could have understood that he has taken the point before the divisional authority or before the tribunal.
So he has a brother by the name of Swapan.
That I find from the, when I kindly see that page 90,
And the brother has been arrested.
page 96.
Brother has been arrested.
Our
Swapan.
brother has been arrested. And 164 statement was there. He could have identified the person's name of what is the name of the father.
164 and complaint both have named Summer,
Summer.
not Swapan. So from where this name has become alias?
When he obtained a warrant of arrest, that something has been done.
No, there is something written about the earlier IO. What is that? You
Can you
see,
see page 96? Paragraph 3, second paragraph. IOC Anil Das Nabodip PS Nodia recorded the name of accused as Samor Mondal in case diary number, CD number, such and such. Suddenly CD number, page 96.
you please have a look at page 90, paragraph 6.
On getting information from the source and others, previous SI Anil Kumar Das identified the accused person who is serving in Indian Army in the fake name of Sopon Mondal, son of Ananda Mondal, of Kaliada, Kotwali, Nodia. Accordingly, he gathered service particulars of accused person.
So has the earlier IO recorded any such finding?
But kindly see that page 96. 96. IO Anil Das. Have you not got it? Page 96.
Yes.
IO SI Anil Das Navadip PX recorded the name of accused person as Samod Mondal in his case diary number, CD number Roman 21 dated 23rd April 2000. Suddenly CD number 21, 24th April 2000, he wrote the name of accused person Sopon alias Samod Mondal. So Ananda Mondal, without mentioning the reason of such addition in his CD, and sent a letter to the commanding officer Pioneer Crops Training Center for supplying the details of the particulars of RP personnel, namely Sopon alias Samon Mondal number such and that.
So this was done by the previous IO.
Previous IO, he has taken up from the previous IO, this gentleman.
But this, see, this is a finding of the inquiry officer.
Mara.
That IO Anil Das recorded the name of accused Samar in his case diary up to number 21. And suddenly in number 22, he wrote the name as Swapan alias Samar. So it is the earlier IO who has done this.
Subsequently, this investigation taken up by this Bhattacharya.
No, if it is by the earlier IO already and he has taken over from there, then
Madakanishi. On 5th, 7th May 2000.
so who's this CD 22? This is whose entry?
CD 21 and 22.
Yes. Where is this CD 22? CD 22 is of 24/4/2010.
Yes. He's a positive. Most probably pending before. Pending before the learner session judge Nodia.
No, that criminal case is over.
Criminal case is over. Over. Over.
Yes. Charge memo also it is the same. And in the charge also said that it was by the earlier IU.
Can you see the charge sheet? Charge sheet.
And what happened to Anil Das? What happened to Anil Das?
Anil Das has not been known. The Anil Das has been known. different proceeding initiated and concluded. And he has pleaded guilty.
Then,
But in spite of that, kindly see the charge sheet. Kindly see page 31 of the charge sheet. On 7th May 2010, crucial date, third paragraph. If took up the investigator noted case as per endorsement, if received a letter from Chief Vijay Singh, Lieutenant Colonel, number Pioneer Unit, Delhi Cantonment by number that number supplemented was posted a unit and he was on 45 days part of annual leave with effect from 19 June 2008 to 2nd August 2008. That you have sent
what,
a
hap-
position to
what,
Vijay
what happened in the criminal trial?
Give me 1 second. He hasn't.
There is an FIR also against this person.
Yes.
What happened?
Should have taken care.
Huh?
Should have
Pen-
taken care.
pending.
I'm not sure because long pending case 2010, we are 2015. We are in 25 because of 2010 incident.
It has concluded or it has not concluded?
We are not, I'm not sure about it. Because our part is only for decision proceedings, not for the trial.
No, against this officer, there is a criminal case also.
This gentleman,
Yes.
no,
No.
only Anil Das has been charge sheeted and pleaded guilty, punishment has been awarded.
Punishment given.
And this punishment has been implemented, he has got the financial benefit, excepting this.
What is the final punishment order?
Page 44. One incremental benefit, page 45. I therefore of considering all aspects of the matter applying the judicial mind, taking all factors into account, it is hereby ordered that.
So cumulative effect means what? It will amount to a black spot.
No. One incremental benefits was.
No, it is with cumulative effect.
That he will not get the refund, but he will get the promotion. Everything will be except one incremental benefits. And he has got the promotion and he is going to retire.
Have you suffered any loss because of this punishment?
I have already got promotion and one only increment. Increment already, my lord, one increment.
One increment remains.
My lord, nothing else, my lord. We already, my lord, got promotion, my lord. My lord, kindly have a look my affidavit in opposition. My learned senior friend, my lord, argues, my lord, this, my lord, kindly have a page number 6 of my affidavits, my lord. Because, my lord, arrest memo, they did not supply. We wrote a letter from supply copy of the arrest memo. They did not give any arrest memo of this, my lord, because, my lord, all in Chondo, my lord, another IO.
But in your written statement, you have not asked for that.
No, my lord. I have a, my lord, copy of this, my lord, opposition, my lord, page number, my lord, page number 48 of my affidavit in opposition, my lord. Kindly have a look. I asked, my lord, and received copy was there. Affidavit in opposition, my lord, page number first 45. Page number 45.
Right.
'45 and 48, my lord.
let us see the report. Then you bring the records once, we'll go through it. We have heard you, we have understood what you're but let us see the records. The learned AGP.
Number two.
Yes. Created the confusion. Case like entry number 20. 23 has started. That the aliens also started. Thereafter, that it is one and the same.
Lordship, item number 2, I appear for the petitioner. On the last occasion, the Public Service Commission has served us with a copy of the result of the type test, my lord. We need some more time to go through that, my lord.
Why
Check.
this proceeding, sir? You are before the single judge, you will examine it. And if there is anything you will say, why this proceeding has to be kept? Unnecessary. This has become infructuous now. It is already a disposed of matter.
Lordship, no, my lord.
No,
No.
it is a different case.
Your lordship remembers.
Non-availability of the bench before the tribunal, they have to close.
Oh, no, I thought that it was that case where there was a proceeding going on before the honorable single judge and
No. It was that case, my lord, where I have prayed that the type test was not a part of the selection process. By virtue of type test, they cannot eliminate. On last occasion, your lordship told them to bring the type sheets before your lordship. It was produced, a copy was handed over to me. But I mean led by Mr. Vikash Ranjan Bhattacharya, my lord, 1 week. Otherwise, I will start because parliament session has started. Your lordship,
then it will come in the new year. Not after 1 year, 1 week. It then will not take it up in these coming 2 weeks. Now it will come after the holiday.
appearing on behalf of the petitioner. On the last occasion, your lordship was pleased to ask the state to file their report in the form of an affidavit. My client wished to, my lord, file exception to the same, my lord.
Some documents are annexed, my lord, admitted documents. Cutting list is fine. That's what it is. Same matter. Report.
Thirteen.
Fine.
The petitioner's counsel would be at liberty to file a
Item number 4.
I'm appearing for the Public Service Commission.
There is no opposition from other side.
4.
Item number 4.
And for the petition, Mr. Rajendra Banerjee is appearing for the petitioner, my lord. He is in court room number 8. Kindly make it short possible.
Order হবে কিনা সেটা তো wait.
In the meantime, I am filing the translated copy of the annexures.
No copy has been handed over to me, the translated copies.
To file chamber.
Annexure.
Well, I'm for the petition. On last occasion, your lordships directed to supply the translated copy.
ওটা দেয়া দেয়া আছে।
তোরই সব
এই তো বলেছিল।
Yes. Well, I am for the petitioner, my lord. Pursuant to acknowledgement, my lord, petitioner made an application, and after the application, my lord, he was allowed to sit for written examination. In the written examination, my lord, petitioner overcome the written examination, and a provisional list was published. In the same list, my name was appearing. Then, my lord, on on 10th December 2019, I made a representation, met with them, and made a representation that regarding information about the written fate of the person, physical measurement test and endurance test.
10 December 19.
Yeah, yes, my lord, 10th December 2019. That is page, my lord, 19, annexer 19, page 34. Page 34, my lord, annexer E. Well, I have handed over the translated copy of the representation. Annexer E, my lord. The Bengali version is also given, my lord. No, when I met with the PSFPs on 9 December 2019, then I came to learn that on 11 2019, interview has been physical measurement and endurance test has been over, my lord. Then I made a representation on the next date, 10th 12 2019, seeking a chance, wherefrom I came to learn that like similar to me, my lord, others were also left out. So, my lord, then I made thereafter, my lord, the pandemic, like entire country was shut on lockdown. I could not contact. Then, my lord, after the situation normalized, I went before them on 2nd December 2020. This document is very vital, my lord. Kindly see. That is, my lord, Annexer 8. Kindly see the Bengali version and English translation. That is, my lord, 2nd December 2020. The date is very vital because, my lord, on that date, page, my lord, about 35, F, Annexer F. Date is, my lord, 12th December 2020. My second December, sorry, I beg pardon, my lord, 2nd December. of 12, 2nd December.
Yes.
On that date, my lord, I have been intimated by an SMS. That is page 40. Kindly see the page 40 of my petition. A residual date of physical measurement test followed by endurance test for recruitment to the post of fire operator under the Department of Fire and Emergency Services, Government of West Bengal, advertisement number such and such have been fixed. Please follow the website for details. This intimation has been given me without intimating that the date of interview when the physical measurement test would be held, the date was not found in the said SMS. On the very next date, by very date, I have received this SMS. Then I have followed. I did not get any intimation. Then, my lord, I made another representation.
On 2nd, this SMS was sent,
Yes, my lord.
but we did not convey the date.
No, that this I have annexed the this document. Even, my lord, there is no venue also indicated. Then, my lord,
Says please follow the website for details.
yes, my lord, I did not get any intimation. Then, my lord, on 17 December, kindly see, my lord, Annexure G of my translated copy. 17 December 2020.
G.
G, yes, my lord, G.
So what we are asking you, it says please follow the website for details.
Yes, well, I have followed their website. I did not get any intimation that the interview is going to be held on. Then when I came to,
There was nothing on the website.
yes, my lord.
Where have you said in your OA? Show from the OA.
Kindly,
Please show. You
Mal-
made a statement of
I am
fact.
coming. I am coming, lordship.
First, you show this fact. Where have you stated in your OA that in your website nothing was there?
That is in my representation. I have stated.
No, show from your OA. You have made a statement of fact.
My lord, in page 4, paragraph 7, that the applicant received an SMS from the respondent authority that residual dates of physical measurement followed by endurance test for the said post have been fixed as such. He contacted with the respondent authority, but they informed him that his name has not been appeared in the list of candidates who have been called for the said test from 9/11/2020, and as such made another representation on 2nd December 2020 before the aforesaid authority with the same prayer to allow him to participate in the selection process, but no steps has been taken on the part of the concerned authority. Then, my lord, that no communication was made on the part of the concerned authority regarding selection process to the petitioner, and it has been completed by concerned authority, and as such made a representation before the Director General, West Bengal Fire and Emergency Service on 17 December 2020 with the same prayer to allow him in the selection process.
So no statement that on the website there was no details. There is no statement. You may say anything in any way you want.
দেবে কি সই করে দিয়েছে আবার নতুন করে করবে
Receive SMS from the respondent authority that residual date of physical measurement.
Last
820
But no steps has been taken on the part of the.
There are 7.
You don't know how you are making this a statement of fact in your submission that you open the website and there was nothing there when your client has not said anything like this in his OA.
We have called for the said test for that, and I said another implementation made on a before the airport authority with the same prayer to allow him to apply. Yes, no. My lord, my humble submission, my lord, that the physical measurement test followed by endurance test for the state post have been fixed. As such, he contacted with the respondent authority, but they informed him that his name has not been appeared in the list of candidates who have been called for the state test from 9/11/2020. And as such, and as such, made another representation on it.
It's the copy of the website, Lordship. And in the reply, I have made out the case, Lordship. Twice the chance has been given to him.
Yes, once on in November 19,
Yes, Lordship.
19/11/19,
Six, the
13/11/19. First date is 13/11. But then perhaps there was something amiss, so you thought
there
it
were
prudent to.
many applications, some due.
Where is your reply? Which statement?
Lordship, my reply is page 41, Lordship. Paragraph 4 onwards, I have made out the case and given the entire details. And in
This date was published on 17/10 itself.
And Lordship, it is pertinent to mention in this particular examination, even the application forms were filed online through the website. So he cannot take the plea that he could not follow the website.
No, if he can't, then that is his bad luck. What can be done?
And page 46.
Where is the annexure?
For page, let's kindly see page 46. That we have got page 46.
Yes.
Kindly see 39, serial number 39. His name is appearing.
This was filed before the tribunal.
Yes, Lordship.
And this was notified on 17/10 itself. You please see, you have said in your paragraph 4 that the commission, considering his representation 10/12/19, decided to fix a date on 3/12, which was published on the commission's website on 7/10. 17/10.
That day also he did not appear.
But
He says he went to the PSC's office on 2nd. He must have inquired whether his name is.
He can go anywhere he wants. That's not the process. The process is that it will be published on the website.
Yes, it was.
And you have to refer to the website.
Yes,
He can go anywhere he wants. Who is stopping him? It's a free country.
But in a guideline, my lord says, my lord, on a very specifically guideline says, my lord, copy দিয়েছো? Well, kindly see that recruitment guideline.
What was not on record before the tribunal, we will not see.
This is the advertisement, my lord. It is also the
Show it from the,
has been
show it from the
derived.
record. Show it from the record before the tribunal. Show it from the record before the tribunal.
But tribunal, my lord.
You have filed an OA. Have you relied on that in the OA?
But the entire selection is come out from this advertisement. Kindly allow me. Kindly allow me to one thing. The document which my learned friend relying, that is the page 46. This is also, my lord, not telling, because, my lord, in page 46 it is found 45 candidates' name are there. In the, my lord, when I bring out a copy from the website, where, my lord, 46 candidates are there. So there should be some transparency, and over the issue of this selection, my lord,
You have filed a rejoinder before the tribunal. You have filed a rejoinder before the tribunal.
Yes.
What have you said?
I've given in
Show from your rejoinder.
These documents are not telling.
Show from your rejoinder what you have said.
But in the rejoinder, I have stated, my lord,
Which page? Please tell us the
Yes,
page.
sir. But in page 3, page 50,
50.
paragraph 6. The sixth line from the bottom. The list of candidates, as has been claimed by the authority concerned, published in the website of the commission, is baseless. A bare reading of the said list clearly reflects that the said document is not beyond doubt, as there is no mentioning of the place and venue of the said measurement test, which is one of the most important point in the notification examination. I further say that another very day, another list of candidates has been published by the respondent authority, which clearly shows that there are 46 candidates. As such, the list annexed by the authority creates doubt, which has only 45 candidates. Well, I have page 53 is the list published by the website. I have take out from the website, and the list given by my learned friend, that is page 46. So both the two documents should be tallied, my lord, and more so, my lord, over this issue of this transparency of this selection process, one division bench hold categorically hold, my lord, the irregularities are found there. That's why the entire panel was recasted. My who presided over, my lord Justice Tandon, and my lord Justice Vishwas was the one of the judge in this division bench, and where it has been held that there is a irregularity found, and the honorable division bench was pleased to set aside the panel.
That is not relevant for you.
Because one second selection process,
Maybe.
and the division bench found
You missed the process. You missed the process.
But my humble submission, then, my lord, on 2nd December, I came before the office of the PSC. They give
That
me.
you have already said.
No, my lord.
That you have already said.
Where is the document, my lord?
That you have already said. That you went to the commission, they did not tell you.
No, what I am saying, my lord, I may be wrong, my lord. Kindly allow me, pardon me, my lord. Can allow me?
No, we are not saying right, wrong. We are saying don't repeat the same thing that you have already said.
I am not just repeating. I am not repeating.
Any other point you are welcome to say.
No. I pardon your lordship.
Yes.
On 2nd December, I went before them.
Again, you are saying.
No, but kindly allow me to finish, my lord.
Yes.
So, your lordship.
You will finish the same thing every time.
No.
Yes.
On 2nd December, when I meet with them,
Yes.
they intimate me by a message that it has been residual date has been fixed. If it is fixed on 3rd, they could have intimated me the 3rd day of the date has been fixed.
But they didn't do it. They didn't do it.
Did not.
That is what you are saying again and again. So anything else we are asking.
And my lord, if anything is, my lord, there's a discrepancy of the document.
That we have seen.
And another thing, my lord, that I am not the landed tribunal hold. I am the lone candidate has been left out.
Maybe.
No, I am not lone candidate.
Maybe
there are 46 candidates who are there. They have
no. After 2nd, after the 3rd December. After 3rd December, you are the only person coming. That is what the tribunal has said. Not saying that earlier you are the only.
On 3rd December, I have not been intimated.
That you have said 3 times. This is the 4th time.
Then, my lord, first one on 19/11, first interview was held. Then I have not been intimated. Not only I myself, there are 46 candidates who are there. Then, my lord, when 2nd December I meet with them, they did not intimate. Then 46 candidates were appeared. I only single person left out. Then I have no remedy. I made a representation on 17th December 2020. They intimate, they did not disclose anything. Then I made a lawyer's notice to them. Then I came to learn that these are the facts has been happened. Then I went before the tribunal and I disclose everything. The tribunal, my lord, kindly see one line, my lord, learned tribunal in the page, my lord, 2nd page, in the middle portion, my lord. The tribunal admitted that unfortunately on this 2nd date also applicant remained absent. Next, my lord, it is an accepted fact that due to exigencies, while some of the dates for testing the candidate may change, and it is obligatory on the part of the recruitment body to notify such change to the candidates either through website or through SMS and email. Well, any mode, my lord, I may be intimated by any mode, my lord. I have not been intimated. This is the simple case, my lord. And it is found that the recruitment body was irregular in selection of the fire operator. That's why the Honorable Division Bench passed an order by directing for publication of merit list.
That is not relevant for you.
So, my lord, so
Yes,
it is
take down. Heard learned advocate.
Number 5.
Grateful, my lord.
I am for the petitioner, my lord. May I please your lordship?
Yes, where's your reply?
Yes, my
Respond number 6.
I'm for the petition. In deployment action.
কপিটা কই?
Yes.
Petitioner before your lordship is the mother of 2 minor child of the deceased employee. The admitted fact that her marriage was solemnized during the subsistence of first wife. But my lord, it is the specific pleading in this case that the first wife has been deserted and exchanged just after 2 weeks or 3 weeks of her marriage. So there is no relations, marital relations with her. And accordingly, the her petitioner's husband, my lord, filed an application for dissolution of marriage, and while during the pendency of that suit, my lord, he died, my lord. Well, it is a specific affirmation also of the respondent number 6, who is the alleged first wife. My lord, secondly, my lord, annexure P12 is the handwritten declaration of the petitioner's husband just before her untimely death. When in that declaration, it has been specifically averred
P12.
P12, my lord. That is the last one. And paragraph 26 of my writ petition, I have stated. Page number 90.
P12 does not bear a date.
Diligence.
P12 does not bear any date.
My lord, no date, my lord, no date. It is just, my lord, written before, my lord, it is a diary maintained by the petitioner's husband, my lord, before his death. Because at the last one, page 92, it is Cholche, it is running on. And my lord, paragraph 26, I have stated, my lord, in this regarding this letter, my lord, paragraph 26. Paragraph 26.
Yes, maybe, but the admitted position is that the first marriage was subsisting and you are the second wife. So how a compassionate appointment can be given to you?
My lord, compare error of judgment, my lord, there are so many judgment, my lord, who is the dependent at the time of the death, who is the dependent. And my lord, mother of the petitioner number 1, herein, my lord, paid for appointment on compassionate ground for the sake and paramount consideration of 2 minor child.
Has she got any benefits?
No.
No benefits.
No, only 50% of provident fund and group insurance scheme.
Only 50% does not mean no.
Yes, madam.
Don't say no.
Yes, madam.
You have got. It's not a case of no.
No, only pension benefit.
So you have got. Yes. 50% of pension.
No.
50% of GPF. 50% of GPF.
Yes, my lord.
Gratuity and leave encashment.
GPF, gratuity and leave encashment. 50%.
No GPF.
Only legal because legal son of the
on the group insurance and gratuity.
Of the second wife, share first wife and other son and the son of the daughters of the second wife.
So the son is getting a share in the pension also.
No, pension only first wife.
No, only group insurance and
so how the son will survive?
Or there is no such. But a pension only to the only one pension.
So from the first wife also there is an offspring.
Yes.
There is one son.
One daughter.
One daughter. From the second wife. That we'll see. Yes.
So only 50% amount.
So your dispute is only about the compassionate appointment.
Yes, my lord. And my lord, 50%.
So tell us how both of you can get a compassionate.
And my lord, and the 50% and the other benefits have not been provided, my lord. Only group insurance and gratuity. I have stated in paragraph 21, my lord.
Where is your prayer in the OA?
My lord. My lord, paragraph page 15, my lord. Page 15 of my writ petition.
We are asking you where is your prayer in the OA?
Prayer I have stated, my lord.
In your OA.
Yes, my lord. Prayer I have stated. Page 15 I have stated.
Why you have not annexed the OA?
My lord, yes, my lord. You supposed to be slow. My lord. In the EBIT things one.
Yes.
But in the affidavit opposition, my lord, no record, no document has been provided with the affidavit opposition as to how the pensionary benefit has been given to the first wife. Or, my lord, how my lord, a prayer for appointment of compassionate ground has been considered, my lord. No document has been. So, my humble submission, if your lordship, unless the record is called for, the entire thing would not be focused before you.
How is it relevant to you? There is no denial that she is the first wife. You are admitting. It is your admission that you are the second wife, she was the first wife. Now she has got some benefit, you have got some benefit. How she has got it? What do you mean how she has got it? She has got it by virtue of being the first wife. Where is the question of any procedure being looked into?
So far, my lord,
it's not your case that she was ineligible, but she has got it. It is your case that you are the second wife and it was solemnized during subsistence of the first wife because of desertion. Therefore, your claim has to be considered.
now,
How she has got is not relevant for you.
this submission allegation has not been considered by the authority at all. That at the time of death, first wife was not present.
So where the scheme says that she has to be present there?
I'm not here.
Where is the requirement that she has to be present there?
Well, there is so many judgment I have got, my lord.
Where is the requirement that she has to be present there? You are making a submission which is not required. The fact of the matter that she is the first wife, not in dispute, why she will not get?
Well, dependency, my lord, dependency, my lord. So far, dependency is concerned.
Wife has to show dependency. Under which provision? So which EMP?
Well, dependency of the
which EMP? Show,
my lord.
show from which EMP you are saying that wife has to show dependency. The income, there is a method of assessment of the family income. That is all. Where is the question of dependency? This is not there in any EMP. Right from 2008, we have seen in so many cases. There is a format for assessment of the family income, which includes the amounts received under the various heads, the interest accruing thereupon.
My lord, Rule 104. Rule 104, my lord. In the period during which pension is admissible, the pension shall be admissible in the case of widower up to the date of death or remarriage, whichever is earlier. But in the case of where note, my lord, where a government servant is survived by more than one widow, the family pension shall be paid to them in equal share. On the death of a widow, her share of the pension shall become payable to her eligible minor children. If at the time of her death a widow leaves no eligible minor child, the payment of her share of the pension shall cease. In case the minor children are twins.
So that is about pension.
So for pension
is
pension has not been also provided to me.
Yes, why pension is not given? For the benefit of minor sons.
No, but a pension will be given only one.
You see, he is referring to that provision.
Rule of 104.
Can you see the expression?
Government rule, what could have said?
104.
Benita কোথায়?
Can you see?
Rule 104 in DCRB.
Yes, my lord. And my lord, section 16 of the Hindu Marriage Act.
DCRB is here. No, must be here. Here. There is one. So how it is?
The member outstanding marriage of null and void, and any child or marriage who have been
গুলো কোথায় রেফার করেছো?
it shall be designated whether such children was born before or after
নোটস অপারেশনটা দাও।
into marriage last and accepted, whether or not it is knowledge of the rights of such children is not protected or accrued accordingly. It is therefore declared that pension payment should be granted to the children from some type of arrangement when the term is 105.
Even a
That there is no claim whatsoever to the receiver.
Even a Siddhappa.
Of the same. After this is very important.
So where is the format
Format for
for the benefits? Is there a requirement to give a declaration that you will maintain all these people? You have got a compassionate appointment also. In the compassionate appointment, you must have submitted a format. So
first wife will submit.
where is the format?
Nobody has submitted.
Huh? Not given. No, so where is the format? Still we want to see.
2013 one.
Yes. Does that format require a declaration?
Yeah, that I've made the family.
No.
I made the family.
Family. Therefore, according to this now, whether they can be ignored. You give a translated copy of this undated write-up, and you give you file paper book to make it convenient to hear the matter. So we can hear.
নোটস অফ আর্গুমেন্ট
Notes of argument.
There is no application for additional evidence.
No, it was not there before the trial. So anyway, we'll see. It is here in that writ petition. We can ignore it. We can. You had your opportunity. You have not filed any opposition
They have filed opposition. They have filed
in this proceeding. In this proceeding.
Yes, madam.
So then you must have taken that objection.
Yes, madam. And all this entry is not relevant.
You have not done. We don't know. Let paper books be prepared.
Was 13.
13. Informal paper.
Informal paper. Whether petitioner is not in a position to meet out the expenses of the of his sons, my lord.
And let formal paper book be prepared. Send it to the department. Then make it returnable on
Department.
make it returnable on 19th or 20th.
January.
7th major operation is going to be held on Monday. But if a compassionate appointment is given to first wife, he is to look after the other members of the family. That should be a declaration.
Item number 6.
Reply file. When? What is the issue? Of the employee concerned.
Then
The employee, my lord, was a temporary employee under the health department for more than 33 years. And thereafter, a prolonged litigation, my lord, he was absorbed, due to which, my lord, he could not, my lord, fulfill the 10 years qualifying service. And your lordship, in the same issue, in the same case, has passed judgment. Only kindly see the reply, my lord, your lordship's judgment. Then my lord, factual background and all those things, my lord, will come on light.
Which page?
My lord, WPST 172 up to page 30. Page 30, your lordship's judgment. Same case. In this case, 4 years deficiency. In my case, it is more, my lord.
Slightly more.
More. My lord, my lord, from the judgment of the learned tribunal and the judgment of the Honorable High Court, it is evident that the circular first issued in the year 1979 to absorb this.
This order has been complied or it is?
It is, my lord.
What is the status?
Appeal has not been prepared so far, my lord. No.
informal ta kote jeg bata.
No. Till date, it has not been, my lord, no appeal has been preferred.
Basic judgment of Nimai Chand.
Nimai Chandra Chatterjee.
9 तारीख 20 तारीख बोले.
My lord. And they have admitted in their opposition that I have joined the service in the year 1975. They have admitted. And certificate issued by the Deputy Chief Medical Officer of Health that I have discharged service continuously from 1975 to, my lord, till the date of absorption, 1979.
Joined in 16 January 2009.
It is substantive service. After prolonged
16 January 2009, he joined and retired on 30th June 2010.
No, that is after his absorption.
Absorption.
No, but
Prior to that, he has been working since 79.
Yes. 75, my lord, 75.
the sanction post.
1975.
There must be a sanction post. They need regular installment.
Which department?
Nimai department.
In the Nimai Chandra Chatterjee, my lord, in the health department, health and family welfare,
As
as DTS spray worker. as DDT spray worker, that is temporary worker. Like you, Gita Noskar, you lordship also decided in the Gita Noskar, the same case, my lord. Similar in the agricultural department, my lord. She was appointed as Khalashi, my lord, and your lordship was pleased to pass judgment directing the government to give notional effect from the date when he joined in the temporary post. But I am seeking only minimum pension, my lord. My lord, the person, my lord, employee have died, my lord, due to starvation and malnutrition. And his legal heirs, my lord, are before your lordship. So, my lord, the petitioner number 1, my lord, the wife of the employee only seeks family pension and the arrear pension.
Unless this period is declared and there is a judgment, unless it is decided in your favor, as of today, what are you getting?
My lord,
Anything?
My lord,
for this period of service, 1.5 years, about 1.5 years.
Only gratuity.
Gratuity.
Only gratuity.
And family pension applicable only if he died in early. Or husband was getting pension. Oh, sorry, husband was getting pension.
So there is no question of family pension.
Family pension when if somebody died in harness, then family pension. And if somebody getting a pension, regular pension, if died.
Therefore, there is no question of family pension.
Yes.
In the pendency of the proceeding, my lord.
So this absorption is for what purpose?
Absorption, my lord.
Observatory only for temporary period.
For what purpose? Why to absorb someone for 1.5 years?
They have accepted that. When this order was passed, there is no, their continuous service will be counted by the court. There is no dictation or direction.
Their absorption is based on an order of the court.
Yes.
Which order?
Can you see the order? They are observing.
We will come back to it.
My lord, order dated 26/9/2001.
We'll see. We cannot conclude right now. We'll come back.
application.
Why this time?
Lordship,
It's of this bench.
this bench.
Give it.
Original side for judgment, item number 1.
The appeal is dismissed.
I was humbly praying, Lordship, I was humbly praying if a stay can be granted to the
There was stay by the writ court judgment also.
court, Lordship.
Yes. Prayer is made for stay, the same is considered and rejected.
Grateful, Lord.
Item number 15.
I for the petition in this.
Matter,
My lord, the polytechnic teachers seeking regularization on the strength of the subsequent judgment. And kindly see, my lord, as per your lordship's direction,
yes.
as per your lordship direction, my lord, I prepared an Excel chart showing the engagement of the petitioner since 2008.
Actually, what we are thinking,
Yes,
take it up after the,
yes,
take it up everywhere.
yes.
It is all right. There is nothing which we done urgently, then we can take.
No, they are working. No, no problem.
Put it in the file.
Obligation.
19th January.
19th January. PM.
We can have it if you want. 2 p.m.
19th January.
Instead of hanging 20th,
What do you want?
20 or 21st?
20th? Both cases.
Yes, yes, yes. 15 and 16.
2 p.m. bolo.
20th or what?
Item number 29.
29.
809. This.
On the earlier occasion, my lord, the appellant number 1 submitted before your lordship.
Yes, we have recorded his submission. Let us just go through it once. Yes.
My lord, I will not repeat the submissions made by the appellant number
So
1.
if we'll just to refresh, the main submissions was that from both sides there have been recommendations at the highest level.
My lord.
Second is according to 47B1F of the Act, they are entitled to be considered as government servants. So the moment they are treated as government servants, then pension has to be given. The third is you are claiming parity with the petitioners of WPST 13475 of 2003. And then you rely on that judgment of Rajasthan and state of Rajasthan versus Mahendranath Sharma. This is the submission which he has advanced. Now what else?
My lord, basically the single bench, my lord, has dismissed the my writ petition on the ground that, my lord, there are 3 grounds mainly, that is non-submission of option and fence sitter. And second one is, my lord, receipt of CPF without protest. And the third one is no explanation for delayed approach. This was the ground on which the writ petition was dismissed. My lord, first of all, my lord, we have raised objection with the pension scheme which was introduced by the corporation, my lord, on the ground that, my lord, they have fixed 37% of DA and no pay commission would be introduced or pay scale would not be granted to us. On that, my lord, we have submitted our objection. Thereafter, my lord, representation was submitted to review the scheme. Thereafter, this scheme was, my lord, was not implemented by the corporation. 60% out of 3,000 employees, my lord, approached the, my lord, they have filed the option. 60%. They have out of 3,000 employees, they have, my lord, submitted their option. Thereafter, since the this pension scheme was not introduced, my lord, or implemented, they have moved the writ petition. This writ petition, my lord, if you lordships kindly consider, option was, my lord, submitted, my lord, this writ petition continued. Thereafter, it was affirmed by the division bench. Thereafter, it carried on to Supreme Court. That was also affirmed by the Supreme Court. My lord, kindly sees one, my lord, the observation of the single bench, my lord, on that. Kindly sees volume 1, page 170 of the paper book, my lord. My lord, my lord, at the bottom portion of the page 170, my lord. My lord, may I read out? My lord, the board's decision of 8th April 2003 is a decision passed without jurisdiction to nullify the pension regulations 2002 as effected from 1st of April 1984 in respect of the retired employees are concerned, for the sole reason that once on due approval of board and sanction of state government, when any regulation is framed and nullified, same becomes a statutory regulation in exercise of power under Road Transport Act, holding status of subordinate legislation, and thereafter to amend or change it. It requires to follow the process of taking a decision of the board, then sanction of the state government, and thereafter to notify it by proper notification in Gazette in terms of Section 21 of the General Clauses Act 1897, which provides that when a notification, when a rule or regulation is framed by the notification, to amend it, it requires another notification following the same process. Now, which one? Not done. My lord, which was not done. My lord, kindly comes to paragraph 35, my lord, thereafter. Hence, in terms of the General Clauses Act, as the Pension Regulation 2002 has not been amended yet, following same procedure by which it was framed, mere decision of board cannot amend or supersede it. Furthermore, a statutory regulation, namely Pension Regulations 2002, framed under Section 45 of the Road Transport Corporation Act 1950, cannot be superseded or annulled by executive decision of board after it is duly notified and gazetted. It is a settled law that there is no substantive difference between a rule and a regulation, in as much as both are subordinate legislation under powers conferred by the statute. Reliance is placed on, my lord, such and such. It is also settled legal position that regulation impose obligation on statutory authorities, and they cannot deviate from the condition of service stipulated by the regulation. Reliance is made in the judgment passed in LIC versus Retired LIC Officers Association. In the angle of those views, the board's decision dated 8th April 2003 has no effect upon the writ petitioners and the retired employees whose service condition is controlled by the Pension Regulations 2002, and they are bound to implement it. My lord, that has not been done.
So why you are reading how it applies to you?
My lord, in this, my lord, the observation was made that the pension scheme which was introduced by the corporation, that has to be implemented.
For?
My lord?
For?
Well, for granting pension to the employees.
No, for which employee?
My lord, these employees were, my lord, who were working prior to 1973.
Where is that said?
1973 आगे तो अपना भी होगा।
हाँ, सब लिखी। It's for all.
My lord, this it was a surgeon. My lord, this was in respect of all the employees of the corporation, man.
Where is it said? Just show us. You are arguing the matter. You have not bothered to go through the judgment.
On the petitioners and other.
My lord, kindly sees, my lord. Paragraph 35 bottom portion has no effect upon the writ.
Mister, we are asking you, it is an observation for whom you have not read the judgment.
No, my lord, I have read, my lord, it has been
stated. Obviously you have not read.
My lord, it has been
you are asking him.
No, my lord, it has been stated, my lord, in paragraph 35. My lord, no effect upon the writ petitioners and other retired employees of the employees.
Yes.
Whose service condition is controlled by the pension regulations.
You please read paragraph 36, 38. That we have already recorded that he is claiming parity.
Parity,
he is claiming parity, he is not getting that, he doesn't claim to be a petitioner. We told you that these 4 submissions we have recorded.
My lord, that is at par with the other state.
That we have told you. Why you are repeating the same
my lord, that option part, my lord. This Supreme Court, my lord, passed the order, my lord, on 2014, my lord. Thereafter, my lord, we have applied by way of representation as per Section 57 of the Act, my lord. That has to be considered as option. But, my lord, that was not done. My lord, the single bench held that we were fence sitters, my lord. We have not approached the court. But, my lord, there are several communications from our end from which, my lord.
Again, you are repeating the same thing. Several correspondence, several recommendation from both sides.
No, my lord, the observation of the single bench was that I have not applied for option. This was
That is not in dispute. You have never made your option. You have made representation. That we have already
but
recorded
my lord, that representation has to be considered
as
an
an
option.
option.
My lord, kindly see,
Yes.
my lord, 57 of the section 57, my lord. My lord, page 90, page 150, my lord. Page 99, my lord, of volume 1, my lord. Kindly sees, my lord, application for grant of pension. Application of these regulations, the regulations in this chapter apply. Page 99 of volume 1, my lord. And it says, my lord, the regulation in this chapter apply to all employees applying for pensions under these regulations. After passing of this judgment, my lord, by way of representation, we have sought for pension, my lord. But my lord, that was not allowed. Thereafter, my lord, we made a my lord representation, and by way of memo dated 8th of March 2011, it was to the transport department communicated to the my lord the employees to wait till the disposal of this pension case. My lord, we have waited till 2014. Once the my lord this matter was disposed of, thereafter, my lord, we have applied for the applied by way of representation, my lord. Subsequently, my lord, there was another observation that CPF was received without protest. My lord, kindly my lord, kindly considers. My lord, we have received the CPF with protest, my lord. Kindly sees, my lord, volume 3, my lord, page.
Volume কত?
Volume 3, page 685. 85. Kindly see the subject.
Page
685, my lord. Kindly sees the subject receipt of the payment of PF amount with humble objection.
Yes.
Thereafter, my lord, we have received the my lord PF amount. Subsequently, while my lord 6/8/2019, my lord, the managing director of SBSTC board wrote a letter to the transport department stating opinion for taking further option, and further receipt of the option pension regulation 2002 can easily be extended to 334 employees who are out of the ambit of pensionary benefits. My lord,
Already argued. Yes. Now go to the next point.
and my lord, lastly, my lord, and my lord, option was invited in the year 2022, my lord, by the corporation, and accordingly, my lord, on 28th 6 2022, my lord, we have applied for option, my lord, that in respect of 2000
Option was invited in 22. By which notice?
my lord, 28th 6 2020. My lord, page 76 of the supplementary affidavit, we have applied for the option, my lord, by filling up the form.
You said option was invited in 22. By which notice option was invited? We are not asking you whether you submitted.
My lord, forms were supplied by the corporation to fill up the same and submit it.
Where is that notification, letter, communication, memorandum, anything?
There was no memo to that effect, but my lord, forms were supplied to fill up and submit it before the corporation.
Who gave it to you?
In the corporation, my lord.
The corporation through which authority? What is your case?
But
Where have you stated? Read.
my supplementary affidavit, my lord,
Read.
page 76.
Supplementary filed in this proceeding.
My lord.
Sorry, we are not going to consider.
My lord, it was a subsequent development, my lord, since it was pending for long, my lord. We have filed this writ petition, my lord, on, my lord, 2018. Thereafter, my lord, this
Prior to disposal of the writ petition.
my
So that supplementary was filed prior to disposal of the writ petition.
supplementary affidavit to this, my lord.
Then we will not accept.
Din, and my lord, one thing, my lord, there was no delayed approach, my lord. There was, my lord, several litigations going on before separate forms of law, my lord. After passing of order,
Anything else?
my lord, and lastly, only 125th meeting, my lord, the decision taken by the board, my lord.
125th meeting is of which date?
My lord, later. My lord, page 155, volume 1, my lord. When the, my lord, this matter was pending before the Supreme Court, the managing directors, SBSTC Corporation, my lord, wrote a letter to the...
Again, you are drawing correspondence. We have told you, don't repeat the same thing.
My lord, only, my lord, only one thing, my lord.
Saying the same point 10 times, does it make it any better? He has said so many times today, or you have said twice. Don't just keep repeating the
No,
same.
there was only this, my lord. There was a direction to consider introduction of pension scheme in 2000.
No, there was a strong recommendation he has shown from both sides. Yes. That he has already shown. Anything else you want to show? Whatever he has not been argued, you are welcome to say.
My lord, my lord.
Or yes.
I appeal for the corporation.
Yes.
Parallel cases which are contradictory and destructive to each other. One is that by virtue of section 47 1B 1F of the 1BF of the Road Transport Corporation Act, they have
Yes.
They have a right of equal treatment like state government employees because they were state government employees. That is one stand. So they should get the benefits similar to state government employees. The other limb of argument, which is the prayers in the writ petition, they say that they need the benefits of the pension regulation. The pension regulation is an exclusive service condition of the corporation. The moment they say that I want the benefit of the 2002 pension regulation, you are acquiescing to the service conditions of SBSTC. You are not claiming parity with the state government employee. These two stands, firstly, are diametrically opposite. Not only inconsistent, destructive, because you cannot claim both. Now, kindly come to the prayers in the writ petition. The first claim will not find place in the writ petition. Page 45 of the prayers.
Which page?
Page 45. Prayers. I'm reading the prayers. Read in.
Yes.
Read in the nature of mandamus commanding the respondents and their main agents and subordinates to implement the pensionary benefits as specified in the SBSTC Employees Pension Regulation 2002 in favor of the petitioner immediately. Next is read in the nature of mandamus commanding the respondents and their main agents and subordinates to pay all area dues on pensionate to the petitioners after adjustment of the returnable amount, if any, from the payable amount as area after exercising option from each of them. So again, not flowing out of the 2002 regulation. C, writ in the nature of mandamus commanding the respondents and their main agent and subordinates to pay the pension, including arrear pension in favor of the petitioners in terms of the spirit of the judgment and subsequent order passed by the Honorable Court and Honorable Supreme Court, as well as the terms of the decision taken by the SBSTC board in its 125th meeting dated 10th June 2010 to implement the pension regulation 2002 in line with the North Bengal State Transport Corporation. So here, my lord, they are saying benefit of the judgment of the first round of the other set of employees and pension regulation.
So this all ultimately all these prayers are only for 2002 regulations.
2002 regulations. So my first submission is, my lord, that if now they make out a case of parity with the state government employees, no prayer is there to support that, my lord, case. This is my first submission. Now, my lord, 2002 regulation, I'll place the regulation. Kindly come to page 87. I'll place that first, then the judgments. Because they want benefit in terms of the previous judgments. I'll show what the court has conferred upon those petitioners. Page 87 is the pension regulation. One is not the short title. These regulations will be called the South Bengal State Transport Corporation Employees Pension Regulation 2002. Then not under serial number 2, sub rule 3, sub serial number 3. The pension regulation shall be optional to the employees as provided in regulation 2.2. This is nature optional nature. Then clause 6 at page 88.
Where is the option? 3?
First is not sub 2, 2, 3.
2, 3.
2, 3. 2, 3. Then will kindly come to 6. 6 will says the employees who may prefer to come under the purview of these regulations shall have to exercise their options within 6 months from the date of actual publication in the official gazette. So within 6 months, they have to exercise their option. This is first. And those employees who will not subsequently join, they have to opt immediately. Then, my lord, kindly come to 6.3. Failure to exercise option by an employee within the stipulated period, as referred to in regulation 6.1 and 6.2, shall be treated as if he had not opted towards pension regulations. If an employee expires before exercising his option, as referred to in regulation 6.1, 6.2, it should be taken as if he had not exercised his option. So non-exercise means that you have opted not for the pension regulation. These are the regulations. Now, my learned friend has already explained how the writ petition was filed in the first round. Only a small negligible portion applied for the pension regulation. Board took a decision not to implement because only 5-6% are applying. That decision
60.
was, no, my lord, it is less than 10%. Less than 10%.
Less than 10%.
6%. 6%. 6% of the employees.
No,
Total
number of persons was 60.
Then opposition. Affidavit, you have stated the numbers. I'll just point out. Opposition to page 582. Then, my lord,
See page 156. The opening sentence.
Fine.
60 writ petitioners.
60 petitioners applied. The optees, they were the optees.
Whatever it may be in terms of percentage, there was 60.
60. There are some more.
But the corporation was of the view that it was too minuscule. So there is no point because everybody is opting for that. That is better. We are going to withdraw.
Fine.
They said no. Now we have exercise option. We must get this. Court said yes.
Court said in discussing in the judgment, court has taken cue from section 47(1)(b) to say they came to the finding that at least these petitioners were state government employees. That finding is final between those petitioners and the SBSTC. But the present set of petitioners were not before the court. So they cannot claim that merely because
there is a finding that they were state government employees.
in the previous round,
Where is that finding?
no, while discussing, my lord, there was a there was a my lord, observation that they might get the benefit of 47(1)(f). They might get, but the court did not give any declaration to that effect, or may not give benefit of the.
We remember correctly, we have read it that day. The court proceeded on the premise that within the time they have exercised their option, now it cannot be taken away.
It cannot be taken away. And the specific direction of the court was that SBSTC will implement the regulation only in respect of the writ petitioners and the optees. Those who have opted, exercised option, the benefit shall be conferred to them only.
Where is that?
Lordship will kindly come to page 171. Paragraph 37. This is the ordering portion.
Who opted?
Yes, it is ordered that the writ petitioners and all the retired employees who opted the pension regulation 2002 are entitled to get the benefits of death cum retirement benefits in terms of the South Bengal State Transport Corporation regulation 2002. Response are directed to take steps for release of the pension and so for the petitioners. This was the direction. Now, it was affirmed by the division bench. It starts from page 173. Here also, the direction remains the same. Parties, my lord. That you kindly come to the last page of the judgment, my lord. It has been specifically provided that with effect from 1/4/1984 till 1/4/97, whatever benefit has been received by the employees shall be treated as benefit received under the pension scheme. The corporation could not have pay any arrears between 1984 to 1997. Furthermore, no provision has been made to enable the employees who retired prior to 1997 to refund the amount received by them. Thereafter, to claim pensionary benefits with effect from 1/4/1984.
We don't find any of this in the last page.
Page 182, my lord.
182.
182. Division bench judge. 182. Single bench lord have placed the operative part. Specific direction. 171 onwards is not single bench. Division bench, my lord. In the middle, my lord, 7th line, my lord. Therefore, it cannot even be claimed by the corporation that the retired employees are being given an undue benefit on inquiry made by us as to why the date 1/4/1984 was stipulated as the date from which we have been informed the pension regulation 2002 would be entered. We are informed that this date was chosen as most of the employees in the state of West Bengal have been made eligible to receive pensionary benefits from 1/4/84. Therefore, it cannot even be said that the date was fixed arbitrarily. A clear logical reason has been given for fixing the date. On due consideration of the entire matter, we are of the opinion that the petitioners, having legally opted to come under the purview of pension regulation 2002, appellant corporation is bound to give effect to the same. We see no reason at all to interfere with the conclusions reached by the learned single bench. We therefore dismiss these appeals and uphold the judgment of the single bench. So that part was upheld. Petitioners and optees to get the benefit. Now, this was the position, my lord. It was given to them. Some other petitions were filed, my lord. They relied upon a judgment of a coordinate bench, my lord, which is now, my lord, stayed by the Honorable Supreme Court, because they were not the optees. They said that after retirement, they had made a representation saying that we want to opt. On the basis of that representation, it was allowed, which has been stayed. So I am not bothering your lordship with that judgment because that is stayed now. Next, my lord. I would be placing the impugned order because not these points raised.
Which judgment was stayed? Is that judgment on the record?
Not on record. Not on record. My learned friend relied on by way of a supplementary affidavit. It is on record, possibly. I'm not correct. Not supplementary affidavit. They have annexed that judgment.
So others have been allowed to make their application.
Have been allowed not to make their application who were not optees in the original set of 60.
Correct. So those who are with whom he is similarly situated, they were allowed to make option. And that has been stayed.
That has been stayed. They said, my lord, that they have made a representation after, similarly like the petitioner, made a representation after their retirement, 4 or 5 years after their retirement, that we have opted. They said that we have already opted, but no receipt was given. That was their case. That we have opted, no receipt was given to us. That was the stand taken by them. This representation, my lord, was not replied to by the corporation. The corporation did not dispute that letter that we have 4 years back we have opted. Court said on the basis of that, court presumed that then there must have been some option exercised by this person. On that basis, it was allowed. But that has been stayed because after 4 years of retirement, if a person says that I have opted, and that is not replied to, that the doctrine of non-traverse will not apply to such a case. That was the point we have taken before the Supreme Court. Because of mere non-reply to that letter, it will not be presumed that you are optees.
But adverse inference will have to be drawn.
Now, my lord, kindly see. We have to, my lord, see. They obtained the, my lord, retiral benefits. This is very important aspect. Here also it happened. The entire CPF, the rate of interest was high at the time of their retirement in 2001, 2002, 2003. They received the entire, my lord, benefits of CPF. They enjoyed it. Subsequently, my lord, with the decline in the rate of interest, my lord, they realized that no, this is not. They have got the benefit of the interest of that part. Now they want to refund and opt for the pension, which the court has held it cannot be done like.
And in the 2002 regulation, does it contemplate refund of the amounts in CPF?
No. Switchover is not contemplated there.
So whatever is deposited, that is theirs anyway, whether they get 2002 regulation benefit or not.
In the 2002 regulation,
Is there a condition precedent to availing benefit under 2002 regulation that they have to refund the amounts lying?
possibly that is there, my lord.
No, not possibly. We want to know. Therefore,
I kindly comes to 57. Those employees who opt, who are already retired from the date of the regulation, they will get 6. Kindly come to page 88.
oh yes, 6-2.
6-2. That is there. Those who were on the payrolls, then retired before coming into force of the regulation. 1/1/84 is the effective date. They were on the rolls after that, but retired before 2002. But these employees are not. But in any case, even they have to opt. They have to opt. They have to refund the amount. Provided third line of 2 million, provided they refund to the corporation the full amount in the share of corporation's contribution towards contributory provident fund together with interest accrued thereon. So they also have to apply immediately. That's 582.
Oh, so those who are yet to retire, they are required to give back the amount lying. And those who have retired and they have availed the benefit, for them there is a provision that it will be adjusted.
Adjusted, no refund interest, but it has to be done within
No,
time.
no refund. In case of those employees who have already drawn the retirement benefit, the amount of such retirement benefit shall be adjusted to the extent possible against areas of pension and other retirement benefits. Any balance remaining remains may be adjusted against future payment. There is no question of refund. It is only an adjustment.
Two sets have been considered. One set is not who have retired prior to 31st March 1997. Those who have retired 31st March 1997. Those who have retired prior to 31st March 1997, they will not have to refund the entire amount with interest. Possibly that is the distinction. 2 and 3. May read not. 2 Roman 2. Employees retiring up to 31st March 1997 may be paid pension according to this revised pattern with effect from 1st April 97, no arrears on account of introduction of this pension scheme may be paid to them for the period up to 31st March 1997. Likewise, SBSTC will not claim refund of the employer's share of contribution towards contributory provident fund. So, if they don't have to refund, but they cannot claim any arrears also up to
So
1990.
therefore, it says those who are still in service, they will give the amount back, and those who have availed the benefit of the retirement benefit, for them it will entail adjustment.
Not all of them. Regulation came in 2002. Now this Roman II
Yes,
and Roman
those
III,
who would apply under this.
those who apply under this, if they had already retired prior to 1997, in that case, my lord, they will not get arrears, but they don't have to refund. And those who have retired from 1997 up to 2002, they shall get the arrears, but they have to refund the entire amount of CPF. That is the distinction. Kindly see Roman II and Roman III. Roman II is not very clear. Employees retiring up to 31st March 97, this part, my lord, may be paid pension according to this revised pattern with effect from 1st April 97. No arrears on account of introduction of this pension scheme may be paid to them for the period up to 31st March 97. Likewise, the South Bengal State Transport Corporation will not claim refund of the employer's share of contribution towards contributory provident fund together with interest accrued thereon, and or any other retirement benefits already allowed to the employees for the period up to 31/7/97. The employees who have drawn gratuity under the payment or other rules shall not, however, be entitled to revised rate of gratuity. And then not each employee retiree have to give his express consent. The other part is not previously. If your lordship sees 6.2, third line, my lord. Third line. It says exercise their option within 6 months from the date of publication of these regulations, provided they refund to the corporation the full amount being share of corporation's contribution towards contributory provident fund. 6.2, third line. So 2 sets of employees. Now, if your lordship kindly permits me, I'll place a few paragraphs from the affidavit in opposition. What was the stand of the corporation? Because the basic facts may not have been stated there. Page 582, volume 3. Volume 3 টা একটু দেবেন, volume 3. Volume 3 ওপরে আছে.
580.
Volume 3. 582. You will kindly come to page 583, my lord, paragraph 4A. That's the basic facts, my lord, I'll place. State that the requisition 583. I state that the requisitioners are appointed in the service of Durgapur State Transport Service, Durgapur State Transport Board, on various dates from 1963 up to the year 1969. All of them retired from the service of the corporation between the period from 2002 to 2010, except petition number 27, who retired on 28 to 1999. In the instant writ application, they have asked for implementation of the South Bengal State Transport Corporation Employees Pension Regulation in their favor. Pension Regulation of 2002 came into force on 30th March 2002. Under clause 2.2 and 2.3 of the said regulation, applicability of the said regulation was optional. Only those employees who opted for the same within the time frame stipulated in the regulation as referred to in clause 6.1 and 6.2 were to come under the purview of the said pension regulation. Then the clause 6.3 has been stated. Then next page, kindly come to page 585. After first line, after a lapse of 12 years from the last date of exercising
What is
option.
it that you want to point out from this? Don't go read the entire thing. What is it that?
I'll just point out one is not the dates when they have retired. I've shown 2002 to 2000.
How are these issues relevant? Who is disputing these facts?
Because of the fact the date, last date of option, their retirement and the date of the writ application, the delay in approaching the court. I just wanted to show this. The first 3 lines have stated the number of years of delay in approaching the writ court, which is
Where is that?
585 minutes. First 4 line. After a lapse of 12 years from the last date of exercising option, and after a period ranging from 5 to 15 years from the dates of their retirement, his petitioners have come up before this honorable court.
589.
585, Miller.
85.
585.
Yes.
First line. After a lapse of 12 years from the last date of exercising option, and after a period of ranging from 5 years to 15 years from the dates of their retirement, the petitioners have come up before this honorable court for the aforesaid relief. The instant writ application is hopelessly time-barred and should be dismissed on that ground alone. So we have specifically given the dates and we have taken the point of limitation that after so many years you are asking for the benefit of the regulation. Then, my lord, I'll not test the other part. I'll just show few things. Paragraph C, you have stated what I have already submitted before your lordship. The meeting was held. It was decided that they will not get the benefit. Then, my lord, I have stated, my lord, that they are asking for the benefit similar to the state government employees. We have made out a specific case that from the appointment letters of the petitioner as well as the service conditions, it doesn't appear that the state government has appointed them. We have elaborately dealt with their appointment. The more government servant has to be appointed with a gazette publication. There was no gazette publication. They were not appointed by the state government. The CEO of the board has appointed. We have stated all these things. So their service condition cannot be that of a state government employee. They were never state government employees. They have claimed that they were state government employees. Then they came to the corporation, which has been disputed.
They are directly recruited.
They were directly recruited by the board. They say that appointment by board means they were state government employees. We have disputed that because for state government employee, a mode of appointment is followed upon publication of their names in the gazette. That was not done. The appointing authority is not state government. The chief executive officer of the board is appointing them, not by order of the governor. So these things we have stated. So we have taken the point that they are not state government employees. Then the point of delay, my lord, an option was never exercised by them. The two judgments do not confer the benefit to those who have not opted. This was the basic case made out. Now, lordship will kindly see the judgment, my lord. I'll place the only relevant pages of the judgment, my lord.
Yes.
Starts from 690. The relevant starts from actually 705 is the lord first page of the order. Lordship will kindly come to 729. I'll not taste the entire thing. Only the relevant findings. From 728, the court view is starts. After recording the submissions, from 728, the court view. Now she will kindly come to 729, my lord. Hence, it is clear, paragraph 37. It is clear that the judgment and order in the earlier writ petition directed the corporation to extend the benefit of the pension regulation 2002 only to those retired employees who had opted for the pension scheme. Undisputedly, the present petitioners did not opt for the pension scheme. Hence, they cannot be said to be in the same position as that of the petitioners in the earlier writ petition. In my considered opinion, the present writ petitioners are not entitled to the benefit of the judgment and order passed in the earlier writ petition. The senior counsel of the petitioners relied on the decision of the Honorable Apex Court in the case of State of Uttar Pradesh versus Arvind Kumar Srivastava. In that case, the Honorable Apex Court held inter alia that normally when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14. It was further observed that this principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by the Apex Court from time to time postulates that all similarly situated persons should be treated similarly. Hence, the normal rule would be that merely because other similarly situated employees did not approach the court earlier, they are not to be treated differently. I respectfully agree with the observation of the Honorable Apex Court, and indeed I am bound by the same. However, the said case does not help the petitioners simply because they are not identically situated as compared with the petitioners in the earlier writ petition. The judgment of the learned single judge in the earlier writ petition cannot be said to be a judgment in rem, in the sense that the benefit of the judgment is available to all the retired employees of SBSTs. The pension regulations clearly provided that the same shall be optional to the employees. Clause 6 of the regulation required an employee desirous of coming under the purview of regulation to exercise his option within 6 months from the date of publication in the regulation in the official gazette. 6.3 clearly stipulated that an employee who did not exercise option within the stipulated time shall be treated as if he had not opted for the pension regulations. Hence, the petitioners not having exercised their option within the stipulated time period must be deemed to have foregone their right to come under the pension. So, this was the finding. Kindly comes to 2. $733, my lord. Or rather, my lord, 733, my lord. So it starts, my lord, from 732, my lord. I'm just reading 3 lines from 732. The Apex Court held that having enjoyed the benefits, 732 last 3 lines. The Apex Court held that having enjoyed the benefits and income from the provident fund amount for more than 22 years, the respondent could not seek to switch over to the pension scheme, which should result in the respondent getting, in addition to their provident fund amount already received, a large amount as arrears of pension for 22 years.
That's why we asked you whether it contemplated refund.
In this case, I have shown 97, and everybody is after.
In this case, there was a provision either for refund or adjustment. Under no circumstance they could get both benefit. That is issue which is taken care of by the regulation, provided you come within the regulation.
Now, we kindly consider one thing, my lord. Maybe they will get the refund the amount with interest, cost of living index at that particular time.
No, that
be taken
there's
care of.
nowhere there is no scope for you to say that. The regulation is very clear. It gives a cutoff date.
Yes.
Prior to that cutoff date, this is how it is to be worked out. Post that cutoff date, this is how it is to be worked out. But provided they come under the scheme, provided they fall under the 2002 regulation.
So to come under the scheme, they have to opt within the time.
That is the issue.
Because if they do it after 20 years, then refunding the amount with interest will also not take them the corporation at par, because the amount at that point of time. And now,
so therefore, exercise of it comes down to exercise of option
within time.
Yes,
my lord, I'm grateful, my lord. So, and then, lord, 733, last paragraph, paragraph 41, the contention of the petitioners that they are state government employees and as such entitled to similar pensionary benefits as other government employees also cannot be accepted. Petitioners may have been state government employees at some point of time. However, once they joined the corporation, they did so on new terms and conditions of service. The corporation has completely.
So there is no, this finding is not challenged by you.
No, it says maybe. There is no specific finding, my lord, that they are state government employees. Previous case, similarly, the analogy of section 47 was drawn, but there was no specific direction that they are state government employees. Here also, it says petitioners may have been state government employees. This is not a finding, not I would say this is not a categorical finding that they are state government employees. The judgment goes on to say that even if maybe they may have been, then also the moment you accept the conditions of SBSTC, you acquiesce to the service condition. Now you cannot, after so many years, cannot go back. If they say that in 1963 or 67 they have come to SBSTC, they have got promotions, they have got the increments as per the SBSTC rules and regulations. Now, 2015, after 40 years, they say that we go back to the service condition of state government. That cannot be done. That is the finding. So, my lord, a judgment of the Honorable Apex Court in a similar case.
Pepsu.
My lord,
Pepsu judgment.
Pepsu judgment has been relied on, quoted with that my lord, once they, after the merger, if they accept
Acquiescence, having retired under that condition, that is Pepsu judgment.
Pepsu judgment. I'm grateful, my lord. So these are the findings of the single bench, my lord. So no, all the issues have been considered, my lord, and the other issue raised by them regarding what the government considering, we also have made an approach. The supplementary affidavit, they have made out a new case that we approach the state government for implementation of similar pension rules for everybody. But government is not the best judgment to decide that. Government has not given any go ahead to the proposal. So today they cannot ask that in this petition. They say at per treatment. That is not the subject matter of the petition, because everything is as per 2002 regulation, all the prayers.
No, writ petition prayer is very clear.
Prayers are very clear.
It cannot be enlarged to.
So, well, these are my points, my lord. The Honorable Single Bench has dealt with all the points, my lord. And because of the fact of delay, because of the fact that they have acquiesced to the service condition, because of the fact that they have received the CPF amount for so long and enjoyed it, all these grounds together, they are not entitled. These are the findings of the Honorable Single Bench. These are my submissions, my lord.
Mr. Sen, you have something to add.
Scope of the writ petition, my lord, already my lord seen that was very limited. That the scope of the writ petition was that after my lord the floating of a particular policy or scheme, specifically the my lord a beneficial scheme with regard to the employees of a particular my lord the organization. Now the state government my lord created a scheme, pension scheme, in lieu and or instead of the already existing my lord the retirement benefit scheme. Now the question is that the state government has withdrawn the state scheme, or the my lord the authority my lord they said that the scheme is not viable, so withdrawn. Now my lord my very my lord simple and my lord the very clear answer is this lordship in that case that the authority which has floated the scheme, they can also withdraw the scheme. Now, at this juncture, the writ petition was filed by the, my lord, more than or almost 60 employees, retired employees of the, my lord, the corporation. They challenged the same. This issue once came up before this honorable court. And my lord, matter, my lord, ultimately reached to the, my lord, the division bench. And my lord, it also appears that the prayer in the said writ petition also challenging the said, my lord, withdrawal of the scheme. It appears from the, my lord, the first page of the order of the single bench as well as the division bench.
The earlier writ?
Yes, earlier writ. The challenge was thrown to the, my lord, the legality and the, my lord, the authority of the withdrawal of the scheme. Now, my lord knows that when a challenge was thrown as a representative capacity, then my lord kindly consider one thing, that it is my lord that is covered to all as a representative capacity, whoever opted to join it there as a party proceedings or not, but union and other 60 employees. Now, whatever it, my lord, I will take it as a representative capacity. Now, a question or a issue was put up for determination before the court of law. Before the court of law, before the writ court, matter went up to the division bench. If the court did not answer to that, my lord, my humble first submission is that it was, my lord, covered under section 11 of the my lord, that is the res judicata of the civil procedure code, explanation 5, that is 1B. That the question raised, but the court did not answer to that. That means refused to answer. So when the refused to answer, that means it comes, my lord, under that res judicata.
Which answer was refused? To which?
Answer refused that with regard to that, my lord, the authority with that withdrawal of that, validity of the withdrawal. Answer to only to this extent that withdrawal invalid up to that. Otherwise, it appears from the order of the single bench and the division bench, who had already, my lord, exercised their, my lord, option or right to opt. That means acted upon that or changed their position on the basis of that promise.
Did they make a prayer beyond themselves? In WPST 143, whatever it is, the number 13457 or something like that. Did they make a prayer beyond themselves?
There was a
It
prayer
doesn't appear so.
at 173. Well, Lordship, kindly have a look.
As far as we remember, it is only for those persons who
173.
this issue was not raised, not considered. No, because it's at the very outset, it says
174, Lordship.
60 writ petitioners.
At page 174, first column of the my lord.
Yes.
At page 174, the prayer was done nicely upon the respondents, calling upon them to so forth, while reading the nature of mandamus shall not be issued, directing them to forbear from giving effect to or continuing to give effect to or giving further effect to, and or withdraw or cancel or giving further effect to, withdraw or cancel or receive the impaired decision if any taken or followed, in not paying pension to the petitioner or followed, or not paying to the petitioner retired from service. And next, my lord, calling upon the teacher, directing them not only to pay pension. So it was challenged before the court. The withdrawal of the pension scheme was challenged before.
No, but it was challenged only by 60 writ petitioners who had exercised option.
True.
Out of 189 who had exercised option, only 60 approached the writ court. And that was the only class before the writ court.
Only class.
There was none other. And perhaps we don't know whether it was by a union or by the individual.
No. 60 petitioners.
60. So it was not by the union also.
60 petitioners.
Because it at the very first sentence it says the 60 writ petitioners.
60.
So it is not by the union. Their cause was being taken up by the union for soliciting the benefit. But the writ petition was espoused by individuals in respect of their own right, which they claim to have accrued by virtue of exercise of option under the 22 regulation.
So, my lord, very good, my lord. So, my lord, I am not on that, my lord. The res judicata point, I am not on that. Then, my lord, kindly come to, my lord, it is, my lord, also one of the averment and they resorted to, my lord, one amendment to a particular, my lord, statute, the Road Transport Corporation Act, 1950. Because according to them, well, all of them, my lord, they were, my lord, they engaged and got their first employment was made prior to 1971. When, my lord, the South Bengal State Transport Corporation did not came into effect, but prior to that, my lord, under that, my lord, the Kuchbihar transport or something else, but not the government. So according to them, whenever the 1950 Act came into existence, and this South Bengal Transport Corporation established under the 1950 Act, and there was an amendment to that. So they resorted to that amendment. Now, she kindly come to it is their amendment. And my lord, kindly come to that is at page number 59. At page number 59. First point that amendments of the Road Transport Corporation Act, they are annexed to this, my lord. Page number 59. and basically that West Bengal amendment and section 47 B and I will kindly come to the bottom. I not within A. 47 BF. This is my lord amendment was carried out. Now what it says, persons employed by the state government, first of all, in connection with the state undertaking and continuing in office immediately before the establishment of the corporation shall be employed by the corporation on such terms and conditions not less advantageous than what they were entitled to immediately before the establishment as may be determined by this corporation. It was dealt with, my lord, in our affidavit also, and possibly by the corporation also in their affidavit, that there it appears that first of all, persons employed by the state government in connection with the state undertaking. It is a state undertaking, no doubt, after the introduction of the Transport Corporation Act, and in 1973, my lord, the Transport Undertaking something on continuing in office immediately before the establishment. Suppose, my lord, let us, my lord, every day be continued there before the establishment of the South Bengal State Transport Corporation. But what benefits should, my lord, they are entitled to, lord, this is very clear. What they were entitled to immediately before establishment. Now, immediately before establishment, in Kuch Bihar Road Transport or other transport where they were, there was no pension scheme. There was no pension scheme. Pension scheme established only after this 1980 or 1981 regulation. So if that is so, when before that there was no pension scheme, then they are not entitled to any such benefit.
Can that be a interpretation of this provision? This provision says that if the person was employed in the state government and he is being employed, then whatever terms and conditions he is getting, he will not get anything less.
Not this advantageous.
So, and that is the only possible way it can be done.
Not less
It cannot be put on a lesser terms.
less advantageous. So I say, I say that
So if they were,
it is not less advantageous.
So if they were state government employees, then on the date of their absorption or their appointment, they could have raised an issue that we are not getting it, we are getting anything less. Whereas his case is that they were never state government employees. They have directly been recruited.
They were never state, yes.
So therefore, there is no question of 47. According to you, there is no question of 47.
I just drew your lordship's kind attention to this.
No, because if they are state government employees, if they were state government employees, then the meaning of this provision is that it cannot be less advantageous than what they were getting in the establishment, state establishment.
First of all, they were not state government employees. Second thing, my lord, where they, my lord, actually engaged.
Was this an issue before the Honorable Single Judge that whether they are
I
state?
think, my lord, it was there, but I.
Because they have not claimed that. They are saying that because of 47(1)(b), 47(b)(1)(f), they are entitled to be treated as par. That is their case.
Now, my lord, I can show for your lordship that because of my lord non-exercise of option, which was a my lord D, because my lord knows the scheme is my lord acting to an act. Because of non-exercise of option, my lord refused to my lord take benefit of the scheme. It is rather waiver. And that was my lord answered in the my lord the judgment of the learned single judge also. It was one of the points raised by me before the learned single judge that it was otherwise a waiver.
Now, my lord, I have, my lord, cited one judgment that is also, my lord, considered by the learned single judge. In the judgment, it has been mentioned herein that one can waive his right anytime, unless that is, my lord, any contrary to any public interest. It's a possibly, my lord, 2013, 2013, my lord.
So by not exercising their option, they have waived. This is
But may I just, my lord, read out it, 2 or 3 pages of the, my lord, the single bench judgment. If you not kindly come to, my lord, the running page 720. Third one. Let's put
724. Yes.
My lord, so for para 28, for my submission recorded in para 28, my lord, I am not on that right now because, my lord, it was because of the reason of the learned senior judge and my submission that for the prosecution. Now I am, my lord, kindly come to paragraph 29. Now the council then submitted that the petitioners have waived their right to claim the benefit under the pension scheme. A personal right can be waived as opposed to a class or sectional right. In this connection, learned council relied on the decision of the Honorable Apex Court in the case of General Manager Siddhartha Gopal Cooperative Bank versus Iqbal, 2013 10 SCC. Then, state finally submitted that having received all retainer benefits under the CPF scheme after such a long period of time, the petitioners cannot seek to avail the benefits under the pension scheme. Such switchover at this stage is not permissible. And then in this connection, the council relied on the Apex Court decision in the case of Union of India versus MK Sarkar 2010 volume SCC, para 11, 15 to 25, in support of his submission. Then, the council relied on the decision in the case of TM Sampat versus Secretary Minister of Water Resources 2015 SCC, para 15 to 19, in support of his submission that government employees stand on a different footing vis-a-vis SPSTC employees.
Yes.
Then, as regards the exercise of option, the council relied on the decision in E. Kannappan versus Union of India through Additional Secretary Ministry of Finance and Company Affairs. Reported in 2015 followed to SCC 623 and Rajasthan Vidyut Vitaran Nigam Limited versus Lower Commission 2015 12 cases, para 127. Now, my lord, if your lordship kindly allow me, my lord, the of these judgments are at present, my lord, but I can show your lordship, my lord, one paragraph only, my lord, paragraph number 90. May I just read out and I can hand it over, lordship. That's paragraph 90. My lord, it is, my lord, reported in 2016, volume 10 SCC at P77.
77.
Yes, 77. So, just one paragraph may I read out. Then I can hand it over, lordship. We have given our thoughtful consideration of the plea of discrimination advanced at the behest of the respondent employees. It is not possible for us to accept that the employees of corporate bodies can demand as of right to be similarly treated as government employees. While it can be stated that government employees of the state of Himachal Pradesh are civil servants, the same is not true for employees of corporate bodies. Corporate bodies are independent entities and their employees cannot claim parity with employees of the state government. The state government has a master service relationship with the civil servants of the state, whilst it has no such direct or indirect nexus with the employees of corporate bodies. The state government may legitimately choose to extend different rights in terms of pay scales and benefits to civil servants. It may disagree to extend the same benefit to employees of corporate bodies. The state government would be well within its right to deny similar benefits to employees of corporate bodies which are financially unviable, or if their activities have resulted in financial losses. It is common knowledge that when pay scale are periodically reviewed for all civil servants, they do not automatically become applicable to employees of corporate bodies which are only financed by the government. So, Father, I have we have another judgment, but I want to cite or rely upon a single paragraph. She kindly wanted the judgment of 2017, column 2 SCC, page 766. 2017, column 2 SCC, page 766. It is also another issue of transport. My Lord, kindly, my Lord, come to, my Lord, the paragraph number 25. At the last paragraph 25.
Yes.
In view of the above, it is well settled that the notice inviting option need not be personally served to the employee unless the regulation or any instruction so provides. 1992 regulations which are being considered in the present case had already been interpreted in page 200 versus Mumbai symbol, that is the RBI. These court having already held that 1992 regulations do not contemplate any personal service of notice to the employee. I think the judgment of the courts will holding otherwise for declaring the truth of the plaintiff are uncertain. From the facts of the present case, it is clear. Although the regulations were enforced from 1992, the plaintiff retired on 30th November 2011, and after retirement received CPF benefits without any protest, and at no point of time before retirement he has raised a grievance. The benefit which was available to him under CPF scheme was received by the plaintiff. He cannot be allowed to have another benefit from the pension scheme which he never obtained. Extending benefit of the pension scheme to the plaintiff shall be extending double benefit, CPF benefit as well as pension scheme, which was never contemplated by the regulation. In any view of the matter, issue in the present is covered by the admitting earlier. So, my lord, the thing is this, that first of all, my lord, one thing is very clear. Whether at one point of time there was no pension scheme. After that, pension scheme floated. Having a rider that who wants to opt, they can opt it, but within a certain period, a fixed period there. Now, in a certain section of the employees, they may be the majority, they may be the minority, but the certain section of the employees, they did not opt. It was their will. It was their will. They did not opt. Then they, my lord, it can be said that you have missed the bus. You have missed the bus because you did not want to ride the bus. So after that, now whether, my lord, the state government can be, my lord, forced to, yes, again implement the scheme. It's a policy. Policy, lordship, involving, my lord, the financial obligation. Whether the recommendation made or provided by, my lord, any corner, from any corner, including, my lord, from the SBSTC itself, the chairman or other, whether that is binding. My humble submission, it is not binding. A recommendation is, my lord, is not binding. After all, the policy of the government is to take a call. The government thought that no, there is no need to, my lord, implement any further, which as once it was implemented, then, my lord, after all, my lord, we have, my lord, withdrew the same. Now, in respect of that withdrawal, it was rightly, my lord, said by the court, the division bench as well as, or the single bench as well as division bench, yes, because of your promise, some of the employees, they have changed their position, they opted, and the moment they opted, that means, my lord, your promise, they have accepted the promise, so you are bound to that, up to that stage only. So, my lord, my humble submission is this, that first of all, it is not a case that there was no pension scheme, there was pension scheme, but you did not opt, that means you have waived that right. Now, after that, when you, my lord, at the, my lord, either, my lord, at the, my lord, when retire or after retire, after having all other, my lord, the alternative benefits regarding provident and other things, you think that now it is much more beneficial. So you say that either through your independent or through organization, that to the government and, my lord, through the, my lord, the corporation, that again it be implemented. My humble submission, my lord, and that is not, my lord, sustainable. Unless and until government itself thinks that all right, we agree. Because it's a policy, my lord, and, my lord, the government may, my lord, implement it, may not again further, but it's a policy, my lord, entirely, my lord, it's a discrimination, my lord, or discrimination of the, my lord, this is fine. Yeah. Okay, allow me, my lord. I can just, my lord, hands up and handle the judgment. 2019, column 30.
Yes.
No, there is no need, because it was on district of foreign. No.
Yes, that's all.
We seek 1 day's accommodation to come with the reply matter, to go through the judgments and come with the reply matter.
The submission, just take down the submissions. Yes, the
My lord, I have a submission, my lord, if you kindly permit.
Yes, call the next case.
Number 115.
My lord, I was humbly beseeching this can be fixed on 11th. My lord, this was fixed on last Thursday at 2 p.m. The bench did not sit on that day.
What
because
is this matter?
So this is my appeal against an order, my lord, allowing an application under Order 21/97, my lord. I am a decree holder. The respondents, my lord, claim to have, my lord, independent right. Now, my lord, this has been allowed, my lord. I am agreed with this one. I am the appellant, my lord. I am led by Mr. S.N. Mukherjee, my lord. This was fixed, my lord.
My lord, it has been assigned matter. It was fixed on last Thursday.
Then may I humbly-
Last Thursday matter did not taken up. Even today they can start. We don't have any objection. But if not, kindly fix it on 18th, my lord. Because Thursday these types of matters are taken up at 2 p.m.
Fix it on
Thursday. That is 18th, my lord.
My lord, this Thursday, 11th, we
my
can
lord,
start, my lord.
This Thursday, this coming Thursday, I will not be in town and I have the advocate on record. Kindly fix it on 18th.
We will make our submissions, my lord. We will make our submissions, my lord.
New Year.
My lord,
Any date, give us.
Any date, my lord.
my lord, this side of the
Just give us a brief background of what the issue is.
Yes, just before, my lord, I take, my lord, to the impugned order.
The next date we will fix only after the holiday. We are not going to conclude it this cycle.
Then in that event, my lord, will kindly, my lord, fix any other. Because, well, this has
Because
to...
it can't be done in the 2 weeks. Please try to
I
understand.
follow.
Just look at the volume of the matter and you.
I bow down.
If you think it can be done, if you can summarize in
it will
20
take
minutes,
some time.
30
It will
minutes,
take
then we will proceed. Why don't you just come with the notes and fix a time? We'll give you a lot you fixed time and you complete it within
Very
that.
well. Any day, if my lord gives us 1/2, we'll complete. Any day, my lord will give us 1/2, we'll complete.
Then it will become endless. If you complete in 1/2, then he will take another day.
Because the facts, well, it's a fact heavy matter, my lord. I have to take, my lord, through the conduct of the judgment debtor and the respondents here, my lord. I need some time, my lord. So therefore, my lord, I was humbly beseeching, my lord.
So when that is why we are asking.
In fact, my lord, this matter was, appeal was fully heard, judgment was reserved. Then Justice Tandon got, my lord, transferred.
When?
This matter, the judgment was reserved. It was for pronouncement of judgment in March, my lord. And then on that fateful day, when the judgment was supposed to be, my lord, delivered in the morning, my lord, day before, evening, my lord, the notification came and he got transferred, my lord. So, my lord, it could not be delivered.
Can you
Standard was sitting with Justice Biswas at that point.
Obviously, that I have understood. That much I have understood. I have now been here for 2 years. I know what is going on.
Matter went for at least 10 days before.
Before Justice Tandon.
Must have no, but see, we are requesting you.
Yes, my lord.
In the interest of expeditious adjudication, please give a very brief list of dates.
We'll do that.
And conclude your submissions. Whoever be try to conclude in a day so that the next day they can.
Yes. And we have the list of date ready. My lord will hear us any day. And we are willing to conclude the hearing, my lord. And the date is ready. List of date is ready. I can hand over right now.
No, give it on that day. You please revise it.
It's fine. Let's so we are going to final.
Don't make it a voluminous.
No, it's not. My lord, whatever, my lord, this is ready. And this, my lord, will go through the list of date. It will, my lord, crystallize all the facts.
So any date, first, second week.
But we can start on this Thursday if my lord is not willing to take up
No,
before the
not,
vacation?
that will be a pointless exercise.
Very well, my lord. Then kindly fix the date, my lord. First week itself, my lord, will. No. The 12th of January, my lord. 12th is a holiday.
12th is probably going to be a holiday, as I'm told, because
Yes.
we know the significance
So,
of
my lord,
the
after
date.
12th, any day.
So it can come on. It is the intra-court appeal. Assigned matter. So it can come on any date. Friday. Should we have it on a Friday?
I'm sorry, my lord.
Should we have it on a Friday?
Any day, my lord, after 12th.
After 12th.
After 12th of January, any day, my lord.
16th is Friday.
Yes, well,
Yes. Take it.
Continue with item number 6.
Yes.
My lord, your lordship passed another judgment at page 41 of my reply annexure Z.
You can show in Nimai Chandra how much was the shortfall.
Before considering that, sir, kindly see the order of the decision bench. Page 29 of the reply. Justice Chakraborty, Justice Talukdar. Starts at page 21.
Page
Page
22.
29. Starts at page 21.
Yes.
Ending at page 29. That is the contribution of inquiry is concerned, the finding was recorded in the first decision, considering several decisions, and therefore you also do accept the petitioner as regards inquiry of the government, particularly when the petitioners are already in service and that are case of declaration or not of initial application. That means from initial date of appointment was not approved by that.
No, that is somebody else's case.
No, that is they are relying that.
You are reading page 29.
22. Starts at page 21. On the basis of this order, HON'BLE letter was issued.
Oh. The state traveled to the Supreme Court and Supreme Court dismissed the SL.
The HON'BLE letter.
It is regularization. I am not saying that it is a appointment. He was absorbed in the service.
Page 40 is the HON'BLE letter. Page 40 of the requisition is the HON'BLE letter.
No, this is only for age bar.
No, but no, when the division bench.
In this case, they were the petitioners.
Yes, Miles, some of them, we are the petitioners and we were absorbed. We are not appointed fresh.
And see the order of appointment. 29 December 2008.
Page
40 of the 29 December 2008. Since the Honorable Supreme Court of India has issued order of the WTSC number Justice Olokta, Justice and scrutiny of the listed they want us for absorption in UP post continuous
Yes.
They have been absorbed from the date of the order.
Correct. Has to be.
Yes. Then if the date of the order is absorption made, but how can that means they are asking for pensionary benefit from the date of initial entry?
No, they are asking for counting of past service.
Past service. Past service.
And for that, you have come out with 100, EMP 100.
Yes, and 1700 EMP.
Where is that EMP 100?
It is discussed in the.
Where is it?
Of the
Where is 100 EMP?
Yes, my lord. Your lordship also discussed that 100 EMP.
100 EMP.
Yes, my lord.
100 EMP says appointed, continuing, and resulting in absorption.
Absolutely.
If we remember correctly, this is the concept
Your
of
lordship
100 EMP.
discussed in the judgment.
It's not a question of any retrospectivity of or that is your scheme. Where is that? EMP 100.
100, my lord, I do not have at this time, but
That is your sheet anchor and you don't have it.
in the tribunal, my lord, in the judgment of the tribunal, learned tribunal also, the learned tribunal. my lord,
Was 100 EMP quoted in our judgment, earlier
yes,
judgment?
yes, my lord. Yes, my lord. Page 30, my lord. 30 onwards.
Page
30 onwards, my lord.
30.
Yes, my lord. Paragraph 3. The facts which are not in dispute, may I read, my lord?
Page 30 of supplementary.
31 of the reply, affidavit in reply.
No, EMP 100 was not.
Yes, page 31, my lord. Page 31, my lord, kindly your lordship's judgment at paragraph 3, my lord. The facts which are not in dispute. May I read, my lord?
You are not DDT spray worker. You are also spray worker.
Yes, my lord. Yes.
Yes. There is a difference. There appears to be no difference.
We'll get the front pension.
Hmm?
If he died in hardness, he'll get the front pension. Now, if he wants to get a regular pension, then employee must have at least 10 years qualification. Whether the period prior to engagement can be counted for the purpose of it.
They were given benefit of a AMP 100 with effect from which date?
13/3/1996.
13/3?
1996.
No.
96.
Engagement letter? Engagement letter as
Engagement letter in the year 75.
no.
Your absorption.
My absorption on 16/1/2009.
16/1/2009, you were given benefit of EMP 100. And you are pursuing this matter since?
Since
this was done pursuant to direction of the tribunal?
Since 1998.
This was done pursuant to direction of the tribunal.
Since 1998.
2009 absorption was made and the original
So
application filed in 2017.
WPST was filed by you in 2001.
No, my lord.
No.
OA was filed in the year 1998, my lord.
No.
876 of 1998, yes. That order was passed on 26/9/2001.
876 of?
876 of 1998.
Where is that?
Yes, ma'am.
Where is the final order?
Yes. My lord, annexure P3 at page 22 of the writ petition.
15.
My lord, page 22. P3. judgment starting from page 25.
Eight seven six of 98. You, all of you are parties to this.
Yes, yes, ma'am.
So this order was subject to the writ proceeding.
My lord, this order was appealed by the state. My lord, in the year 2000. In affidavit in reply, my lord, I have annexed the division bench judgment. My lord, WPST number 1282 of 2001, page 21 of the affidavit in reply. Start from page 20, my lord. Along with 1281, 1282 also taken.
Thereafter, it traveled to the Supreme Court also.
Supreme Court dismissed the SLP.
Where is that?
The summary rejection. Page 40 is a summary rejection.
Page 40.
In the
40.
Page 40, while quoting the order of the
The Honorable Supreme Court, India passed the order, but unfortunately, my lord, inadvertently, I could not annex the same. But in
Page 40 or 14
It was SLP dismissed. Can you see the affirmative letter?
of the writ petition.
Yes. The court order of the Supreme Court has been quoted.
No, where is the order?
I don't have it. Copy to go there. No, এখানে নেই, এখানে নেই। Reply নেই।
My lord, this is the order, my lord. No. Inadvertently, I have not annexed with the reply, my lord. In the
What is the date of judgment of 1281?
so, my lord,
WPST?
19/9/2008.
No.
WPST 13/7/2005.
22 to 2005.
13 July 2005.
Huh?
13 July 2005.
My lord, this is the Supreme Court order.
What is the date?
Date, my lord, Supreme Court order 19/9/2008.
And when they issued the absorption order?
My lord,
When they issued the absorption order?
16/1/2009.
No. 29 December 2008.
I joined on 16/1/2009.
29 December 2008.
And joined in 2000.
16/1/2009. Sorry,
2009.
sorry, man.
So from 98, they have been pursuing the matter to get it after 10 years.
But division bench while deciding the issue, dealt with whether there would be past service should be counted or not. For a kind idea. Their point was available to them that our past service should be counted for the purpose of pension and gratuity. This issue was made a question was
Prior to absorption,
when absorption has been granted by the court.
where absorption has been granted?
Order of the division bench at page 29. In the
No absorption was granted. Relaxation in age was granted.
the case of regulation order not for initial recruitment.
But no absorption was not granted. It was they were being said they were being deprived by saying that they have crossed the age. That was the issue. So the age bar issue hurdle was lifted by the division bench. In spite of lifting of the age bar, you still did nothing. And before the tribunal, what was the prayer? At that time, you were eligible.
Yes, my lord, I abandoned all prayers, only sought minimum pension. Tribunal also, I also sought for counting of first service.
In OA 876 of
For
19
regularization.
for regular, there at that time you were within the age of regularization.
Yes, ma'am.
From where we get the prayer?
My lord, the OA application is not with me.
No, is it there from the order passed by the tribunal? It must have considered what your case is.
So many OA applications taken up analogously, my lord. And after considering the submissions of the learned advocates appearing on behalf of the respective parties and considering the judgments, their lordship, my lord, observed that principle at page 35, the writ application.
Yes.
Principle to be followed.
So there was a specific direction that the applicants who have entered for the first time after 31/12/99 be excluded.
No, I was engaged in the year 1975. So yes, my lord, yes.
Those who have come after that, they are to be excluded, and the others given the benefit of paragraph 5 of 100 EMP. So pursuant to this direction, benefit was not extended. You cross the age bar during pendency of the writ petition. Writ court said lift the age bar. What is their fault? They have been running for more than 20 years.
35 years, my lord. 35 years, 1975 to 2010.
And they are only asking for minimum pension, 10 years.
But we are bound by the rules. Rule 36. Minimum 10 years qualifying service.
And you are not bound by Rule 17.
All rules are we are bound. But
Then Rule
we are
17.
executive.
Rule 17 is also binding.
But whatever the rules are framed by Article 309, that is binding upon the government.
So therefore, they are seeking implementation of Rule 17.
17, 18 and 22.
17, 18 and 22. DCRB.
DCRB rules, 1971.
Right. 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 That's one. Still not clear. They went. They decided in 5. Or there must have been a bar. This court said this by this is not trail. Relax the age. So effectively this order has already given a relaxation for the right adoption. That they have been doing it since 98, otherwise they would not have been relaxing them the completely. Import finally dismissed. So from 98 to 2008, 10 years, the litigation has been thrust upon. Whether they can be made or not. This is exactly what I have decided. I'm saying install this.
Yes, but just show us 100 EMP. EMP 100 and Rule 17, 18 and
Rule 17, 18, my lord, it is discussed in the judgment, my lord, Nimai Chandra Chatterjee versus State of West Bengal. My lord, at page 135.
is quoted.
Yes, my lord.
All the 3 provisions.
Yes, my lord.
Page?
Page 135, my lord. Paragraph 9, my lord.
$135.
Paragraph 9, my lord.
17 is not quoted.
Seventeen of the DCRP rule.
You don't have the DCRP with have a copy of EMP, 100 EMP.
I had the provision, Mamata.
Can you give us in 5-10 minutes? Is
100
it possible to give us in 5-10 minutes?
100 EP.
Yes, no. Today it cannot be given.
I shall have to collect from the well.
It is not there in any of these books. Huh? WBSR.
My lord, your lordship has quoted 17, 18 and 22 at page 41 in the case of Vitanaskar and others. Affidavit in reply. Your lordship has quoted it.
Page 41.
So page 45, my lord. Rule 17, Rule 18 and Rule 22.
And 100 EMP, is it anywhere?
So also similar case, my lord. Seasonal Khalashi.
No, your case is similar to the other one.
Hiral Ghosh.
He was also DBT sprayed.
Yes, yes, my lord.
Hiral Ghosh has been implemented.
Yet not, my lord, complied with, nor any appeal has been preferred before the Honorable Supreme Court. It is under process. It has been informed that it is under process for implementation. And government also, lordship, kindly allow me, my lord. In education department, pursuant to order passed by the Honorable Single Judge and Division Bench, the government issued notification, my lord.
No, see.
Handover.
Before you hand over, you have to understand one thing. That they were trying to carve out a distinction so far as DDT spray workers were concerned, because their nature of work was seasonal. Whereas in the other departments, they were continuously working. So that was finally laid to rest by that judgment. So that may not be very relevant. They are doing it in other departments, but they wanted to keep you on a different pedestal. It's a seasonal worker occurring twice a year, maybe 4 or 5 months in a year.
My lord,
120 days.
We have worked, my lord, continuously.
So that
My lord,
the facts are slightly different. Yes.
Chatterjee also seasonal Khalashi.
Route 17.
No, Rule 17 we have got. It is quoted in one of our judgments. 17, 18, 22. 100 EMP, if you can give us. All right, if you don't, we'll find it. We'll find it. Tomorrow we'll conclude this. For further submissions.